The Honorable Chief Justice and Justices of the Supreme Court of Pennsylvania. Oyez, oyez, oyez. All manner of persons who stand bound by recognizance who otherwise have business before this court be now here and they shall be heard. God save the Commonwealth and this honorable court. Please be seated.
Good morning, everyone. Welcome to the third day. It's been a long week. Welcome to the third day of our spring 2026 oral argument session here in Philadelphia. The Pennsylvania Supreme Court is the oldest appellate court in North America. Our roots date back to William Penn's Provincial Court of 1684, and our court was formally established pursuant to the Pennsylvania Judiciary Act of 1722. In May of 2022, we celebrated our 300th anniversary with a special session in Old City Hall here in Philadelphia. We on the court are very proud of our rich history. In 1996, 274 years after the establishment of our Supreme Court, Madam Justice Sandra Schultz Newman became the first woman ever elected to our Supreme Court. On September 9th, 2025, we gathered in this courtroom to bestow a very special and well-deserved honor upon Madam Justice Newman by renaming this historic courtroom the Madam Justice Sandra Schultz Newman Supreme Court Courtroom. Sadly, Justice Newman passed away last month on February 2nd at the age of 87. Justice Newman was an inspiration to me and to countless other women in the judiciary and to the legal profession. May her memory be a blessing. I would like to introduce some students who are here with us today. They are from my alma mater, Lincoln High School in Elwood City. The students are part of the AP U.S. Government and Politics class and the American Government class, and they are here with their teacher, Mr. David Gabus, and their other chaperone, Ms. Carrie Smith. So students and chaperones and teacher, will you stand up so we can acknowledge you? Thank you. We're so happy that you're here with us. I believe this is the 14th year, Mr. Gabus? That's roughly correct. The 14th year that Mr. Gabus has brought his students to Philadelphia for an educational trip. They come in on the train and they spend a couple of days exploring the historical aspects of Philadelphia with its rich history, and they always spend one day observing our oral arguments. So we're happy to have them. I'm always hopeful there'll be a future lawyer in the bunch. I'm not sure about that this year, but counsel, try not to dissuade them from a career in the law during your arguments. I'd now like to turn it over to Justice Mundy to talk about a very special video that we're going to show before the arguments begin. Justice Mundy?
Thank you. As part of our celebration in May of 2022 of the court's 300th anniversary, we put together a group of attorneys from across the state to decide how to celebrate the court's anniversary. And as part of that program, we started looking at the rich history that our court has, and we decided that it was very important to place a marker to mark the place where the Supreme Court first formally sat here in Philadelphia. Now that was prior to 2022 and probably around 2018 when we first came upon the idea that it really would be important to mark the place where the Supreme Court first sat. And all I can tell you, it has been an odyssey to get our marker placed. And here we are, so happy in September of 2026 to now place this marker. So I want to give my congratulations to the Pennsylvania Supreme Court's Historical Commission for completing one of their very first projects, and also to give my heartfelt thanks to Stacy Witalik, Nikki DePasquale, and Brian Minner, among many others who worked tirelessly to finish this project.
Thank you for showing the video. Thank you, Justice Mundy, and thank you for the leadership that you provide to our Historical Commission and for all those who were involved in putting this together. It's an important event for our court. Before we hear the first case, I would like to remind counsel of a few things. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of the case. Please begin by introducing yourself and your co-counsel and identifying the party you represent. The justices are familiar with your cases, so we ask that you avoid any unnecessary recitation of facts or procedural history and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for particular issues. In cases where there are multiple parties represented by separate counsel, counsel should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices when they are asking you a question. A justice's question is not meant to trip you up. Rather, it indicates that there are particular issues that we wish to explore further. I remind you that in our court we do not allow rebuttal. Finally, while we have no set time limit for argument, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, we need just a moment. All righty. Call the first case.
Commonwealth of Pennsylvania versus Charles Clayton Cassell III and Karen Scott, representing Mr. Cassell and Scott, Mr. Anthony Marino, representing Commonwealth, Mr. James Zonkovich.
Pursuant to Section 2506 of the Crimes Code, an individual commits the crime of drug delivery resulting in death where he intentionally administers, dispenses, delivers, gives, prescribes, sells, or distributes any controlled substance in violation of the Drug Act and another person dies as a result of using the substance. In this appeal by allowance, we granted review to consider, number one, whether an individual who is charged with this offense can negate the delivery aspect by showing that the victim either actually or constructively jointly acquired, possessed, and/or used the drugs. And number 2, whether such defense warrants a jury instruction on constructive possession. Good morning.
Good morning. May it please the Court, Chief Justice, Attorney Zamkitovich. My name is Anthony Tamburino. I am from the York County Office of Conflict Counsel, and I represent the appellants Charles Cassell and Jared Scott in these matters. These appeals ask whether joint acquisition and use of drugs negates a delivery under drug delivery resulting in death, and in the case of Cassell, his murder 3 conviction, which relied on a delivery in order to prove the murder 3. There was first insufficient evidence of a delivery in these cases, as the parties jointly acquired the drugs they used together. Even if there was sufficient evidence, the trial court's denial of the requested jury instruction on the defense was an error which should be reversed. The unpublished Superior Court opinion in Commonwealth v. Brown and the Third Circuit's decision in United States v. Semler found that no delivery occurs when co-users jointly acquire and possess drugs for shared use.
Counsel, the Brown opinion to which you're referring was only joined by the author himself, right? There was only Judge Bender. The other 2 on the panel did not join that, right?
I believe one joined in the result and one wrote a concurring dissenting opinion.
There's no precedential opinion from the Superior Court in support of your position, is there? There's an unreported single judge opinion by Judge Bender.
And that's correct, Your Honor, but we're relying on the general concept of joint use and acquisition as a constructive possession, joint possession between 2 people when 2 individuals simultaneously and jointly acquire possession of drug for their own use, intending only to share it together. The only crime then would be simple possession, and then thus there couldn't be a delivery between the 2.
But the transfer, the furnishing of the drugs from Cassell to Smith met the statutory definition of transfer. Isn't that correct?
Well, I don't think it did, because you can't transfer between 2 people who jointly possess something.
Is that correct as a matter of law? Don't the cases and the statute indicate that this met delivery? In other words, isn't your argument more with the what the General Assembly has codified rather than with the court's handling of the case?
Well, I don't think it is, because I think a transfer requires a transfer of possession here, and we don't have that when 2 people jointly acquire drugs together. And we can presume, I don't even know if we can presume that's what happened in Cassell. For example, we don't really have evidence of who obtained the drugs in this one. We both know that they showed up in the vehicle together at Chase Smith, the dealer's house. We don't know who got the drugs first. We don't know who handed drugs to whom. What we do know is that they decided to use together, and they went and bought the drugs together. So, and I appreciate that Commonwealth v. Brown is an unpublished decision, but it does rely on factors set forth in the New Jersey Supreme Court case State v. Morrison to assess facts that demonstrate joint constructive possession.
But counsel, I'm not sure how you get there. I mean, delivery is defined as transfer from one person to another. And I don't think that it's impossible to say that one in actual possession of something can transfer it to someone who also had constructive possession of it.
But I think there's required to be a possessory transfer. And the reason that I say that is because, for example, in the case of Murphy, which I know the Commonwealth relied on, Murphy was a constructive transfer case. It wasn't an actual transfer case, but Murphy still required a shift in possession. So Cassell's case involved no third party or agency. It was just 2 co-users who showed up to Chase Smith's house. They bought drugs together, and then they shared them back and forth. Under those circumstances, they both had the power and intent to control at the time they acquired the drugs. So there can't be any type of possessory transfer between the two. So under those circumstances, this court.
But counsel, where in the statute is there an intent? The delivery is the physical act of transferring. That's what the statute says. You're trying to impute an intent to deliver, and that's not what is within the statute. Share with us why your argument gains more weight than the plain text of the delivery definition.
Well, the drug delivery resulting in death statute requires a knowing delivery. So there has to be some knowledge that you are delivering something to someone. But you can't deliver something to someone if they already possess it.
But how did she already, Mr. Cassell purchased the drugs from Chase Smith, and he then, your client Cassell, then shared the drugs with Angelique Smith, and she died. So he delivered them to her. It doesn't matter that they shot up together, right? It doesn't matter that this is a sympathetic case and et cetera, et cetera. That the act of him furnishing her the drugs meets the statute, doesn't it?
Well, I don't think it does, because I think the statute still requires a possessory transfer. And that makes the most sense, because
why isn't there a possessory transfer? You're using that phrase in a very esoteric sense. I mean, the statute requires transfer from one person to another. It's a physical transfer. What is not possessory about I have something and I give it to Justice Wecht, I'm transferring it?
Not drugs, something other than
something other than drugs.
Well,
yes.
And I appreciate that question, because there's a lot of obviously examples that have gone over through my head as to what I would use before this court that makes sense. And I think the easiest way to explain it is if you two decided, and this is an example that I believe is used either in Semler or a case that Semler cites called Weldon. If you two decide to order a pizza together, you both have possession of the pizza once one of you takes possession of it. You both expect to have some of that pizza. So if you take the pizza and put it in front of you right next to each other, when Justice Wecht takes a piece, he expects to have that piece.
That's just not how this statute, and I don't think that's how this statute envisions it. I go to the door, I get the box of pizza. I bring it in, I put it on the table, and I say, here, have a piece of pizza. Under this statute, I've delivered. I've transferred a piece of that pizza to my colleague. Now, is it stingy? Should there be an exception for joint use? Maybe, but it's not here, as I see it.
Well, I would disagree that it's not here, because under Murphy, this court relied on the fact that there needed to be ownership by the individual who was directing somebody to transfer drugs. So this court does contemplate the fact that there is going to be a possessory transfer, and it relied on what the Superior Court said in Murphy by looking at definitions of what transfer means, and it looked at it as a possessory transfer. So if you look at what the Superior Court said, which this court actually said it agreed with, it talked about dominion over the drugs in that case. It talked about possession and ability to convey. And you can't do that when both of you agree to purchase the drugs together and both contribute to it.
But how did Cassell not have dominion when he bought the drugs from Chase Smith, came back to the car, furnished them to Angelique Smith? Why does it matter that he and Angelique shot up together? Why does his act not constitute delivery within the meaning of the statute?
First, in Cassell's case, I don't know if it's exactly clear who bought the drugs. I don't think that was made clear because Chase Smith didn't testify. The Commonwealth did make an argument that Cassell made a statement that he let Angelique Smith use as much drugs as she wanted. But if they both decided to purchase the drugs together, and that is what happened here, Cassell did, when she called Cassell up and said, can you come and get me, Cassell did ask her, do you want to use?
You don't have any precedent from any Pennsylvania court that allows us to get into this joint decision-making calculus, do you? Because if we did, that would take us down a rabbit hole of trying to figure out the thought processes of groups that are purchasing drugs.
Well, I mean, I understand Your Honor is not impressed with the Brown decision as an unpublished decision.
Well, it's a single judge. There was Judge Bender's opinion, Judge Kunselman, CIR, she concurred in the result, and Judge Collins concurred and dissented. So you have no, and that's an unreported decision in any event, so you have nothing there.
I understand that, and now it's before this court, and this court would have to make a decision as to whether there's any way to reconcile whether that's possible. I would say under that decision that there is. As I was starting to mention, that court did cite State v. Morrison, which set out different factors to look at as far as what would demonstrate joint acquisition and use. And those were whether it was a personal or commercial activity, the statements and the conduct of the parties, the degree of control exercised by one over the other, whether the parties traveled and purchased together, the quantity of drugs that they purchased, and whether there was sole possession. And when you look at Cassell's case, Cassell and Smith had an ongoing personal 2-year relationship. They knew each other well. They knew each other's habits and preferences, especially regarding drug use. So when Cassell asked Smith if she wanted to use drugs and she said yes, the implication was there that they were going to get together and use together. That's the mutual plan to buy and use together. That's what they always did.
It's a great test.
That's an excellent argument to make to the DA on why, somebody should have gone into the DA's office and made that case, because this case was definitely overcharged and definitely oversentenced, but I don't see how we can do anything about it on either end.
And actually the test that you read would be an excellent exception to the statute that we currently have. I mean,
But it's not.
We need to do a whole lot of maneuvering to read that kind of test into the clarity of the statute that we have. And I don't disagree with you, it's harsh. But we can't actually do anything about that, in my opinion. My colleagues may not think that the statute requires the reading as an actual physical transfer, but I think our case law supports that.
Well, obviously, I would have to respectfully disagree with that, Your Honor. And we've talked about this a little bit, and I would still say that there is the opportunity, there is the requirement of a possessory transfer, and we don't have that when two people jointly agree to do this, and that this court could make a test, such as the one that the New Jersey State Supreme Court adopted in Morrison, to do that.
In effect, though, wouldn't we be rewriting the statute? Wouldn't we be legislating if we did that?
I don't think you would be, because I think we have a concept of constructive possession. And one of the things that I would say is that obviously constructive possession when we're talking about drug delivery is something that the Commonwealth uses. And I argued in my brief that this is a sword versus a shield. Well, prior to the fact that there had to be a knowing delivery for drug delivery resulting in death, nobody is going to say, hey, I constructively possessed drugs with this guy who was delivering them. They're not going to do that because they're implicating themselves in a felony. But when you...
Everyone should do drugs alone, then.
Well, that might not be the safest thing to do, but the point here is that if it requires a knowing delivery, then that would mean that joint possession is still on the table here. So under those circumstances, the courts can look and assess as to whether there is a joint use and acquisition and whether that eliminates first the element of delivery at all for proof, or whether there should be some form of an instruction given on joint possession. In both of these cases, there was joint possession. I'll talk briefly about the Scott case, but the Scott case I think is even more clear because the drug deal took place in the vehicle with all three. Scott went and got the drug dealer came back and got in the car with them, and the money flowed from Savage to Wandell, Savage is the victim, to Wandell, who was his friend, to Scott, to the dealer, and the drugs flowed back from the dealer to Scott.
Scott's the middleman. How is that not delivery?
Well, he's not the middleman because they agreed to go together and buy drugs, and they ended up using together. So they all contributed something to this. Savage contributed money, Wandell contributed transportation, Scott contributed his knowledge of dealers and I think he even used a Suboxone prescription to buy something to cut the fentanyl with, and then he contributed the location of where they could do drugs together. And that's what they ended up doing. So here, any actual possession was momentary, and literally, as I understand the transcript here, the testimony of Wandell, is Scott took possession of the drugs, handed them to Wandell, and she handed some to Scott. That was, at best, momentary possession under Semler, and they all possessed it at the same time because they all had conscious dominion and intent to control those drugs together. They were all in the car together. They all had equal access, and they all...
Can I just interrupt for 1 second? I think we're talking over each other in some respects. You're essentially asking this court to fashion a Swiderski instruction which would negate an element, I guess the element of transfer, based upon some kind of joint possession or constructive possession theory. Have you submitted a proposed language for such an instruction, and is that something that this court can do as opposed to something the General Assembly should provide via statute?
We submitted a proposed jury instruction, I believe, in Cassell. It was put in as an exhibit.
Is that part of the record here?
It is part of the record in Cassell. To be honest with you, I'm uncertain if we submitted an actual written request or if it was just discussed on the record in Scott, but it was discussed as to what a joint possession-like instruction would be under these circumstances.
Let me ask you this question then, because there's a lot of talk here about our role as opposed to the General Assembly's role. The doctrine of joint possession or constructive possession, is that something that the General Assembly came up with, or is that something that the courts fashioned in order to deal with situations where you had multiple people in close proximity to, say, a gun or drugs to justify a conviction where there was no actual possession?
Well, constructive possession is, I believe in a number of cases, it's called a legal fiction, and I'm presuming it was developed by courts. So
that's my point, because we're talking here about the General Assembly's role as opposed to our role. To my knowledge, constructive possession is something that the courts came up with, and they came up with it to deal with the facts of multiple people in a room or multiple people in close proximity to either a gun or drugs, something along those lines, to justify a conviction. But the General Assembly didn't identify constructive possession. The General Assembly didn't identify or codify joint possession. That was something that the courts came up with, correct?
Well, it is something that the courts came up with, and then I think and I would say the courts came up with it because the courts had to find a way to deal with the concept that when somebody is not actually possessing something, they can't get a conviction.
They came up with it to expand criminal liability.
Correct.
Joint possession is, you want to turn it into a theory to reduce liability, which would take a legislative enactment, an amendment to the statute, wouldn't it?
No, I mean, I don't think it would take an amendment to the statute because the courts had to come up with the theory to deal with just the concept of somebody not physically possessing something. And under the circumstances, as I already mentioned, nobody's going to cop to not possessing drugs that aren't in their possession if it hooks them up with a felony delivery. But in this case, the legislature knew about constructive possession and knew about joint possession. Those concepts have been around since before probably our first drug act. So when they know about it and they amend statutes to allow for an easier knowing delivery element, that doesn't change the fact that they're still in play as a concept. So I think this court can actually say, when there is joint use and acquisition, the defendant is at least entitled to an instruction to that so the jury can properly assess, kind of what we all intuitively understand, whether you want to make a, buy pizza example together or one of the various examples that were used in Semler where just passing drugs back and forth or passing a bong back and forth would be considered delivery. And I think that's why, I'm presuming that's why this court took this case, and I do think this court can say that is a legitimate defense. The legislature doesn't have to enact anything for that to be viable to be used to deal with delivery for drug delivery resulting in death. They knew what they were doing when they amended the statute to a knowing delivery. They knew that these concepts were in place. They knew it was possible that somebody could actually say, hey, you know what, I didn't actually deliver drugs to this person. We went out and bought them together.
All right, well, you make an ambitious argument, and we'll take it under consideration.
Can I just ask one more question?
Sure.
In the definition of delivery under the Drug Act, it talks about the actual constructive or attempted transfer from one person to another of a controlled substance, whether or not there is an agency relationship. What does that mean?
My understanding of the agency relationship language had to deal with in the 70s when there was this concept of a buyer's agent or a procuring agent, and they just, in essence, eliminated that aspect as to you can't make a claim for yourself that you're just buying drugs for the buyer so that you're not part of the sale. And I don't think that really applies here, because when two people agree to buy drugs together, they are doing it jointly and they are possessing it jointly, whether one actually possesses them momentarily and one constructively possesses them. They both have a power and intent to control under a joint possession theory.
But one has actual control. One has actual control of the drugs.
But joint constructive possession only requires equal access and joint control. And under this court's decision in Macalino and the Superior Court's decision in Gilchrist, it doesn't matter how much control there is, they just have to have some of it. So in the case of Cassell, where he let her use whatever amount of drugs they wanted, well, that cuts both ways. That indicates that she had some control to use the drugs, and she had equal access. This all occurred in the vehicle together, so she absolutely had access to the drugs.
Thank you.
All right, thank you, Mr. Tamburino. Let's hear from the District Attorney's Office. And, sir, would you pronounce your name for me?
Zamkatovich.
Say it again.
Zamkatovich.
Mr. Zamkatovich, welcome. Please proceed.
Thank you, Your Honor. Madam Chief Justice, members of the court, my name is James Zamkatovich of the York County District Attorney's Office. Our position is that in this particular case, in addition to the fact that we don't believe that the exception that is attempting to be crafted here is appropriate, factually, under this standard of review being raised as a sufficiency of the evidence, the record in this case does not support the defendant's argument. The drugs in both of these cases were never jointly held. In both of these cases, the drugs were held entirely by the individuals that finally delivered them until they were delivered. In the case of Mr. Scott, he was literally a purchasing agent that the two individuals, Miss Wandell and the victim, Zach Savage, brought in because the dealer they contacted, he was unavailable, and apparently Mr. Scott was, since he was on the other end of the phone. The agreement was that they would take Mr. Scott into the city, he would buy their drugs for them, they would give him the money, he would give them their drugs. This is no different than if I offered to take one of my coworkers' money to a coffee shop and buy them their coffee. Upon returning, I would give them their coffee and their change. In the testimony, specifically NT at 201, there was testimony presented that the drugs given to Wandell remained in Wandell's hands. Those drugs were used by Miss Wandell and Mr. Savage. Now, there would have been an argument in favor of this exception had the Commonwealth charged Miss Wandell. Those two were truly in the same position. The Commonwealth, in its discretion, declined to charge Miss Wandell. In the case of Mr. Cassell, there's testimony, in fact, it's less testimony, it's the defendant's statement to police, where he conceded during the statement to police that he gave her as much as she wanted, NT 217. This is relevant because testimony was presented that Miss Angelique Smith was picked up by him, by the defendant, from rehab. At that time, she had no money, she had no cell phone. He possessed the only means to obtain the drugs. And that's where the Commonwealth's argument landed, and that's our belief why the jury found guilty. To Justice Weck's opinion about the sentencing, I do want to note that in Mr. Cassell's case, there are extenuating circumstances that happened during the course of her overdose and death, which are the basis for the malice for the third-degree murder. That's why the sentence is so long. If it had just been a straight DDRD, it's unlikely the judge would have imposed as strong a sentence as what finally came out.
Counsel, are you of the opinion that there is room in this statute for a defense of joint acquisition and use? It's just not this case?
That's a fair argument. There's also an argument that the current structure of the statute precludes this.
Well, I'm asking you, does it? Or is there room within this statutory language for that defense?
Currently, in light of the small amount of medical marijuana statute, when you're reading the entirety of the drug delivery statute as a whole, comparing the 780.113A30 versus the A31, the A31 expressly includes as small amount, rather than delivery, a transfer of marijuana under 30 grams between users that is not for sale. By virtue of that provision in the small amount of marijuana, it demonstrates that the legislature had the ability to create this exception that is being advocated for actual delivery of, in this case, fentanyl. In light of the fact that the legislature did not invoke its authority to create such an exception, the only reasoning would be that the legislature did not create that exception on purpose. So as of right now, given the current structure of the statute, that exception does not exist under Pennsylvania law.
Mr. Sanakovich, what's your thoughts on the Swiderski instruction that the Third Circuit gave?
I'm sorry.
How do you reconcile the Third Circuit's instruction in Swiderski with the concept of joint and constructive possession? I mean, let me give you a hypothetical, because you're going to argue the facts of the case, and we're not really an error-correcting court. We've got to deal with other issues. You and I decide we're going to buy some crack. We go up to a crack house. We knock on the door. You and I pull our money together. I hand $20 to the crack dealer. He hands me a little baggie over. He hands you a little baggie over. There's 6 vials in it. You immediately take 3 out and give me 3 and the other 3. I smoke mine. I die. How does that reconcile with the joint and constructive possession argument or the Swiderski? Do you think that should be punishable as transfer? Dangerous or drugs resulting in death?
For that, Your Honor, I hate to say it, I would have to find additional circumstances in order for us to prosecute that. That's a situation where our office would not exercise the discretion to proceed, much like we chose with Ms. Wandell, where the defendant, who was the transactor with the field dealer.
You're talking about the exercise of discretion by a locally elected district attorney. I'm talking about whether or not the courts should allow a Swiderski type of instruction under Pennsylvania law because of the joint and constructive possession argument.
As of right now, given the structure of the statute, Your Honor, I'd have to say no. The moment that the items transfer from one person to another, a transfer does occur, an actual transfer, which is included in the definition of delivery.
And
so,
not to make your argument for you, but you're arguing that the General Assembly recognized those types of transient or temporary kind of situations in the marijuana statute. The fact that they chose not to put it into this particular statute shows that they don't want it as a defense.
Correct, Your Honor.
Any other questions? Thank you very much. Thank you both.
Thank you, Your Honor.
Good argument, both of you. Thank you.
Aloia, Stimson versus Diament Building Corp, representing Applts, Mr. Howard Bastion, representing Diament, Mr. Cassell.
In this appeal by allowance, homeowners filed a civil action against the builder who constructed their residence more than 14 years after the construction had been completed, alleging damages resulting from the builder's failure to comply with various building codes. The trial court granted the builder's motion for judgment on the pleadings and dismissed the homeowner's action with prejudice, finding that it was time-barred under the statute of repose relating to construction projects in Section 5536 of the Judicial Code. Section 5536 bars civil actions brought against a person lawfully performing construction filed more than 12 years after the completion of the construction. In doing so, the trial court interpreted the phrase lawfully performing construction as relating to a builder's general licensure or authority to act, rather than the builder's strict compliance with regulations, ordinances, or other law while performing the construction. As such, the trial court concluded that the builder performed the construction of the homeowner's residence lawfully under the statute of repose because the builder was licensed to perform the work and certificates of occupancy had been issued for the property. Based on its recent decision in Johnson versus Toll Brothers, which interpreted the same challenged language of the statute of repose, the Superior Court agreed with the trial court's interpretation and rejected the homeowner's contention that the builder was not entitled to the protection of the statute because their action alleged building code violations which rendered the construction of the home unlawful. Additionally, the Superior Court clarified that the period of repose commences on the date that construction is completed, which is the date that the certificate of occupancy is issued. We granted Alicotter to examine the propriety of the Superior Court's rulings in this regard. Please proceed.
Good morning, Your Honors. My name is Howard Bashman, and I represent the plaintiffs' appellants, Thomas Aloia and Amy Stimson. With me this morning are Jennifer Horn of the Horn-Williamson Law Firm and Todd Bartos of the Bartos Group.
Welcome.
Chief Justice Todd, and may it please the Court. Pennsylvania's construction statute of repose, originally enacted in 1965, is unique throughout the United States because it is the only one that conditions the availability of repose on whether the defendant is lawfully performing construction. What does lawfully mean in this context? Both federal and state law prohibit the use of lead paint in the interior of a residence. If a licensed home builder is applying lead paint inside a home, is it lawfully performing construction? According to the defendant, the answer is yes, no matter how unlikely that seems. Throughout the first 58 years of its existence...
Mr. Bashman, could I just stop you right there real quick? Because I want to dig down into what you're saying. Lead paint, the type of paint would have to be approved by a local building inspector, right? In other words, we know how construction works. You submit plans, some plans are reviewed by the local ordinance to make sure they meet all building codes. If a contractor basically submitted plans to build something and said he was going to use lead paint and that was in violation of the building code, wouldn't the building inspector say, you can't do that and I'm not going to issue a building permit if you're using lead paint because it's illegal?
My hypothetical is not that the plans included expressly stating that lead paint was going to be used, but that it ended up being used. And so that whenever a certificate whenever somebody goes to the municipality and asks for permission to build.
Get a building permit. They submit their plans and they ask the plans to be reviewed by the building inspector. The building inspector reviews the plans and wants to make sure that they comply with all of the building codes.
The first step, which is requesting the permission to build a property, involves going to the municipality and asking for the permit, the building permit, and the building permit that issues under the International Residential Code, which applies here in 2003, requires the builder to perform in accordance with the building code. And so if the builder is not performing in accordance with the building code, the builder is not performing in accordance with the permit that he received. And so these cases involve instances where the builder did not build according to code, even though they were required to do so. And
now, looking back 20 years or so, in other words, here certificates of occupancy were issued 2006, 2007, no problems came to the fore at that time. Water infiltration starts to be experienced by your client, a later acquirer of the property in late 2018. So does the lawfulness not apply to the process of permitting that went on back in 06, 07, rather than looking back all these years later?
Justice Wecht, I think the answer to your question is that the issue is whether building code violations existed when the construction was completed. That's what the statute of repose speaks to.
Question whether the process was undertaken lawfully at the time it was undertaken, rather than looking back after the repose period fly-spec the thing and see if some fault could be found in the process back at the time.
No, we don't agree with that in full. We do agree that getting the building permit is necessary to obtain permission, to obtain the benefit of the construction statute proposed, but that is not the end of the analysis, and that the Superior Court erred in concluding that it was. In fact, under the first 58 years that this construction statute proposed was in existence, before the Superior Court issued its Johnson versus Toll Brothers decision in 2003, the statute of repose was construed to require a home builder's compliance with the minimum requirements of the applicable building code to be available. Those are decisions dating back to 1975. They're cited in the Brunken decision that we included in our brief. The sky was not falling before Johnson, nor will it be falling again if this court holds that lawfully performing construction requires complying with the law in the form of the applicable building code. The applicable building code is the law that has been adopted by the jurisdiction.
Mr. Bashman is, sorry.
Oh, it's a distinction to me between is the contractor lawfully performing or performing those duties in a lawful manner, performing the construction duties, or is he lawfully entitled to perform the duties? I mean, I think you can argue this both ways, but I think there really is a distinction there.
Absolutely. Among the three things I hope to cover here this morning is precisely that point. What does lawfully mean? In addition, I hope to cover what our understanding nullify the statute of repose, which is what the other side's arguing, and we vehemently disagree with that.
Well,
and then,
Justice Brobson had a question.
Is a failure of a contractor to build to code a deficiency in construction?
I'm not sure I understand what the deficiency in construction term means.
I'm asking you as we're standing here today and having a conversation,
right.
Is a failure to build something to code a deficiency in construction?
It certainly could be, and it could certainly give rise to a claim for negligence per se.
It could be. I mean, if a building is not built to code, that would be deficient construction, correct?
Well, I guess, yes, I'll accept that, but I think that we recognize that there also has to be proximate cause existing.
There has to be damages.
Well,
harm.
If the argument is that the railing on a balcony on the upper floor of a home is not the proper height, which violates the building code, if the damages that are being claimed as moisture infiltration in the basement of that property, that might be...
Okay, let's not look at causes of action.
Right.
Let's simply look at, do you agree that failure to build something to code is a deficiency in construction?
I agree that it is unlawful conduct under the code that was adopted.
So you don't agree that it's a deficiency?
Well, I'm not sure if Your Honor is focusing on language from some other provision.
I'm just having a conversation, Mr. Bashman. I mean, I'm just trying to understand.
I agree.
You're an intelligent man.
We
have some high school students here who know what deficiency means. I'm just asking you if you agree that a failure to build something to code would be a deficiency in construction.
Yes.
Okay. If that's the case, how do you explain A1, which specifically says you have to bring any claim for a deficiency in construction within the statute of repose period? Your construction that you're offering here would eliminate A1.
We don't agree that's correct. And let me just grab my copy of the statute. Just bear with me for one more moment. Here it is. So A itself requires that the person was lawfully performing construction before you get to what it covers. And so, yes, a deficiency in the design, planning, supervision of construction, or construction of the improvement would be covered if the builder was lawfully performing construction.
You'll never be able to bring it within the 12 years. You'll never be able to bring an A1 within 12 years if, under your view, you were never lawfully performing in the first place.
That That is not correct for the following reasons. The construction statute of repose would not apply, as I explained earlier, where there's no proximate cause, where the claim is based on ordinary negligence as opposed to violation of the code, which plenty of claims are based on, where the claim is based on a violation of industry standards, where a claim is based on the failure to follow manufacturer instructions, where the claim is based on asbestos, lead pipes.
You want to have it both ways. You want to invoke a provision that's applicable only when the person is lawfully performing, but then you also want to make use of it on the theory that he's not lawfully performing. It has to be one or the other. So doesn't that suggest that lawfully performing means it wasn't some buccaneer builder throwing up a shack without permitting? It means, was the thing built in accordance with the laws that governed at the time? And then you have to bring it with it. Then the 12-year repose period begins. Isn't that how it works?
The idea that the General Assembly in 1965 was trying to encourage builders to obtain permits and certificates of occupancy in order to gain the benefit of the statute of repose after 12 years seems unlikely, because if you're a builder that is not planning to announce that you're doing the building, having the ability of the statute of repose does not seem to be something that would encourage that entity to.
No, I think I would phrase it a different way. I think when the General Assembly created the statute of repose because they wanted to have a robust industry for home building and construction available, and the industry lobbied for the statute of repose because unlimited liability would increase the value, cost of construction and things like that. A compromise was reached which was like, we'll create a statute of repose, but we're only going to protect the builders that are doing business legally, meaning they're getting all their permits, they're certified, they're licensed. We are not going to protect fly-by-night builders who come in and leave and have no licenses and no experience whatsoever. Those people, no statute of repose protection.
We don't disagree that that's part of the inquiry. And in fact, the General Assembly, we know, was not seeking to provide repose to the greatest extent possible, because it picked a 12-year period, which is one of the longer ones, and it included the word lawfully in the provision, which did not exist anywhere else. But
Counsel, doesn't that phrase, taken in context, mean that the person was authorized to perform whatever it was that he was engaged in? And doesn't the permit authorize that person to perform?
It means that plus more. And the more is comply with the building code. Where does the more come from?
I mean, this language applies to the person, the person's ability, the person's qualifications, the person's
license,
authorization. It's brought against any person lawfully performing. It's not concerned with the building per se. It's concerned with the qualifications or authorization of the person.
We think that the more natural and better understanding of the phrase lawfully performing construction is not merely licensure alone, but rather whether your act of performing construction is lawful in its details. And if I can just explain.
Back at many, many years later. I mean, that seems to be more of a in the limitations context, you have the discovery rule, right? So your theory of liability, where you within that context could avail you in a discovery, more something akin to this latent water thing. So you've got the discovery rule in limitations, plus you don't have privity anymore. So in addition to those wins, you also want to get a win here to do away with the statute of repose. And so basically, these builders would never have relief from causes of action brought many years later under your theory. Am I wrong?
Well, I explained earlier the very large number of scenarios where they would have the benefit of the statute of repose. This only involves building code violations, which is the minimum requirements that the law provides. And the question of whether this court should adopt some cramped, overly restrictive, partial understanding of the word lawfully as defendant urges, instead of the most natural understanding. The word lawful, I did a Westlaw search last night in preparing for the oral argument today. Most of my preparation was done before last night, I can assure you. But I searched in the Pennsylvania Statutes and Court Rules database for the root lawful. 2,195 responses came back. The defendant asked this court to hold in essence that someone who consumes 8 shots of whiskey, becomes intoxicated, and then gets behind the wheel of a car is lawfully operating a motor vehicle so long as he or she has a driver's license. And the court in that Right to Farm Act case, whose result we don't have any quibble with, we're not asking this court to say that the Right to Farm Act case in Branton reached the wrong result, but in a footnote there, the judge wrote that a simple illustration will demonstrate the difference between what lawful means and legal means, and said that if someone is speeding, they are lawfully operating the motor vehicle, but they're not legally operating the motor vehicle. But if you look at Black's Law Dictionary, and also this court's decision in McCandless from 1893, which is cited in the briefing, but both of those resources present the definition of lawful as encompassing many more things than just the word legal, which is more narrow. And so when the court in Branton said that someone driving above the speed limit is lawfully operating the motor vehicle, it got it just backwards.
So just to stop you there, so as I understand what you're arguing is that any building code violations that occur or are in place after 12 years would be actionable under your reading of the statute. Is that both latent violations or any violations?
Well, obviously, it is certainly latent violations because the statute of limitations. This case was decided at the judgment on the pleadings stage, and so if there was a violation that was obvious to the homeowner.
Well, as I understand your complaint, the violation in this case was that the stucco went all the way to the ground instead of 4 inches above it. So to my understanding, if you looked at the wall, you would see whether the stucco was 4 inches above ground level or all the way to the ground. So it's not a latent defect. And why should, on what I'm assuming is an obvious condition, why should you be giving more than 12 years to claim it?
I agree with that 100%, but it's important to know that the complaint in this matter, and the operative pleading is the Second Amendment complaint, alleged numerous code violations and also said that those were just by way of example. And the fact is that someone can't look at a building from the outside, meaning the building inspector, when the construction is finished, you can't look at a building from the outside and see the stucco and know that there were the necessary 3 layers were put on, that the stucco is of the necessary thickness, that the water barrier that's supposed to be under the stucco consists of 2 layers versus 1. And so it's our argument that if the builder only puts one impervious layer on the building, it's not lawfully performing construction while it's doing it. Now I'm responding to their present tense, past tense argument. Or if it only puts on 2 coats of stucco and not the third, it's never lawfully performed construction. As I was saying before.
It's deficient.
Mr. Bashman?
It's deficient. It's deficient.
But that subpart 1 only applies if you have the benefit of A, which is lawfully performing.
But again, I want to ask you that question. You said you're arguing a limited exception or limited definition of lawful, right?
I'm saying they're asking for the most limited on the other side.
Okay. What deficiencies in construction would still have to be brought within the statute of repose period?
Ordinary negligence, violation of industry standards.
Why does a violation of industry standard have to be? That's the same thing as a code violation.
No, it is not. The code is minimum standards only. The next category is not following instruction manuals, and then I also described a whole bunch of different particular types of claims.
Aren't those negligence claims?
Yes, they're negligence claims, and the
Wait,
violation...
so explain to me again, so deficiencies in constructions include negligence claims. What deficiencies in construction claims have to be brought that are not part of lawfully performing in your scenario?
Are you asking me now whether someone can behave lawfully while they're performing negligently?
Yeah, that's what I'm trying to understand, because why would the General Assembly say all deficiency of construction claims have to be brought within the statute of repose period, and then turn around and say, but certain deficiency in construction claims don't have to be brought within the statute of repose period? That's what I'm trying to understand.
Let me give a two-part answer to that. The first part's very quick. Our argument is not that negligent behavior violates the law as used in the construction statute of repose. The same way that someone wouldn't say that someone who is negligently driving a car is necessarily violating the law, or negligently building something is violating the law, unless it violates the minimum standards. And then we also know that the building codes are part of the law that the municipality has adopted. And then thirdly, we know that the General Assembly in 1937 enacted a statute, which we cite in our brief, Section 4102, which says that violation of building codes equals unlawful construction that may be restrained by the municipality.
Mr.
This is
Bashman, let me stop you there, and I may have missed this in the record. Did West Pikeland Township issue building code violations?
Did they issue building code violations for this property?
Yeah. I mean, your claim is based upon this alleged stucco. You keep talking about building code violations, building code violations. Building code violations are issued by township officials, or either the code official or the building inspector. Were they issued in this case?
They were not issued, but can I respond further to your question? The building code itself says that even where a certificate of occupancy issues, and a Superior Court decision recognizes this as well, that is not conclusive proof that there were no building code violations. And the reason is, if you look at the building code, the inspector only has to be there at specific instances. And so defects in the building envelope, which is the term that describes what keeps the inside of the house separate from the outside of the house, cannot be observed once the house has been built over that building envelope.
I understand that, but you keep arguing about building code violations. The only people that are authorized to issue a building code violation is a code official or a building inspector. You earlier, in response to my other question, you cited the IRC. The IRC even says it. If you take a look at page 33 of the IRC, it says that the Building International Residential Code is clear. It is up to code officials and building inspectors only, and not private plaintiffs, to determine whether a provision of the IRC has been violated. You keep citing the IRC and claiming a building code violation when none have been issued, to even trigger the statute of repose.
But ultimately, it's going to be a court that decides whether the law has been followed or not.
Ultimately the court. It's ultimately, if you're saying there's a building code violation, it's ultimately up to the township officials who perform building code inspections to issue a violation or not. We can't do it. No court of common pleas can do it.
No, my argument is not that some building code violation had to have been issued by the municipality. Obviously, that did not occur in this case. But when an expert comes into a case and says that the property suffered from these building code violations that were not spotted by the inspector, who's only there at limited times, and we know that I think the argument can't be made that just because every house has had a certificate.
Your argument's taken in another direction. If I think there's a building code violation in my house, the first person I'm going to call is not Howard Bashman, with all due respect, or Ms. Horn or anybody else. The first person I'm going to call is the Philadelphia building inspector to come out and inspect and see whether or not there's in fact a violation of the building codes. I'm not going to call a plaintiff's lawyer and hire an expert to come out and say, well, there is a violation. And even if there is, the first person I'm going to call after that is going to be the building code inspection to issue the violation. That seems to be the predicate to me, because your argument is based upon alleged violations of the building code.
My client has to prove a building code violation to prevail on its claim. We acknowledge that. And that's the way that court cases proceed. The fact that there's this administrative aspect to it is not the final answer to whether a building code exists or not in a court of law. I appreciate Your Honor's point, which is that the hope is that the building inspector would discover building code violations, but we know as a fact that a certificate of occupancy has been issued for every residence in Pennsylvania, presumably. And this court cannot say that definitively proves that every residence in Pennsylvania has been constructed.
Let me ask you, I'm thinking about the implications of your argument. Isn't there a tautology in this? You want to say that the whole theory of your complaint is something was done unlawfully, and by definition, and it's premised on the theory that way back then something was not lawful. So it seems like your whole attempt to avoid the statute of repose collapses the two together. In other words, you assert this cause of action on the basis that something's been done unlawfully. And it's premised, in turn, on the theory that way back when, in 2006, something was done unlawfully.
Correct.
It's tautological. The attempt to avoid the statute of repose, I think, veers into absurdity, doesn't it?
I'm not sure. I mean, I guess one of the questions I was expecting to receive today possibly is, what if somebody brings a suit 30 to 50 years after the construction was completed?
200 years.
Right. How does somebody prove that that was done unlawfully? And I think my responses there are, if you can prove that the code was violated, if the code existed at the time that the construction occurred, then you would have a claim under the statute of...
Isn't that absurd?
You would have a claim.
I mean, this is a statute of repose. This is not a statute of limitations that we're applying the discovery rule.
We understand that statutes of repose can have harsh consequences, but we also believe that here the General Assembly adopted a statute of repose that included this word that was not used anywhere else in a context where registration and even permits were not required throughout the Commonwealth in 1965. And if the General Assembly wanted to say if the builder or architect is licensed or permitted, those were terms that were known and available in 1965 and would have avoided the whole issue of what lawfully means. Lawfully can have the very narrow argument that the other side suggests it should have, but we believe it should have its proper full understanding.
Well, why Mr. Bashman? Let's assume, in this statutory construction case, let's assume the term is ambiguous. What statutory construction principles would you have us apply to say, number one, your interpretation is reasonable, and two, represents what the General Assembly intended?
Right. And so we begin with 53 Pennsylvania Statutes 4102, which is the Municipal Housing Ordinance Authorization Law, enacted in 1937.
Why are you beginning there? Why aren't you beginning with this statute?
What words in the statute are
what I'm saying is that the term unlawful construction was used in that earlier statute, and here it says lawfully constructing.
It does not say lawfully constructed. It says
lawfully performing.
It says any person
right.
lawfully performing.
Right.
And what you're doing is you're collapsing A and A1. I mean, as I read this, tell me what I'm missing here. As I read this statute of repose, something I'm not a real fan of, but here's how I read this statute of repose. It says if a person is lawfully performing construction, then that person is protected by a 12-year statute of repose from any deficiency in his performance. You want to collapse those two things. I mean, this anticipates somebody is authorized to perform. If they are so authorized to perform, they're getting a ride after 12 years. You can't sue them after 12 years for any deficiency in that construction that was performed pursuant to an authorized construction person.
Our point is that that is part of it, but that lawfully is an adverb that modifies performing.
There you go. That's the nub, isn't it?
Right,
A person
not a person.
performing.
So lawfully doesn't modify
Well-
person.
That's what we're going to decide, and perhaps next year Mr. Gavis will bring his English class to try to discern which modification, which adverb, which phrase the adverb is modifying. But we understand your argument, and it's very well done. Are there any other questions for Mr. Bashman? All right, thank you so much.
Thank you.
Let's hear from your opposing counsel. Mr. Coyle?
Madam Chief Justice.
Are you going to expertly perform your oral argument, or are you going to argue to us in an expert manner?
Are you lawfully entitled to perform all
Do you have a license?
I have a bar license, so I am lawfully performing this oral argument for you this morning. May it please the court, my name is Casey Coyle. I represent Diament Building Corporation in this appeal. I'm joined today by my co-counsel Blair Granger of the Granger Law Firm. At first glance, Your Honors, this appears to be a statutory interpretation case. But upon further review, it's really an attempt to revive expired claims through judicial nullification of the construction statute of repose. Section 5536 is undisputably a statute of repose. It was enacted by the General Assembly to extinguish all liability for alleged construction defects 12 years after completion of construction of an improvement to real property, save two limited exceptions in the statute. And for the last 60 years, courts throughout this Commonwealth have faithfully applied Section 5536 or its predecessor as the jurisdictional bar it was intended to be, protecting architects, carpenters, engineers, home builders, roofers, plumbers, and others in the construction industry, union and non-union alike, from indefinite liability. What you just heard from opposing counsel, plaintiffs do not want there to be an end date for construction defect claims. Instead, they want to convert Section 5536 into a statute of limitations, whereby a mere code violation tolls the running of the 12-year repose period until some unknown future date. But plaintiffs' never-ending liability theory cannot withstand scrutiny. First, plaintiffs' interpretation is antithetical to the entire concept of repose, which is to provide a firm, definitive date after which a defendant is assured no liability whatsoever.
Well, that argument, though, presumes there are no exceptions ever to a statute of repose, and there are.
There are, Your Honor, but we're not invoking any of the enumerated statutes exceptions here. Secondly, plaintiff's entire argument is based on a syntax error, because the dispositive phrase is not lawfully performed, past tense. It doesn't appear anywhere in the statute. It's lawfully performing or furnishing in the present tense. Third, plaintiff's view disregards the actual language of the statute, as Section 5536 plainly keys the commencement of the repose period on the completion of the construction and nothing else. Fourth, it violates the basic rules of grammar. And I'm a visual learner, so I'm going to take out my copy of the statute. Let's start with the structure of the statute. There's three subparts. Subpart A, the general rule, B, the exceptions, C, the limitations. The dispositive language here appears in A, the general rule, not in B. Why is that important? Because in the reply brief, plaintiffs suggest that the term lawfully was really intended to be a latent defects exception. That's contrary to the structure of the statute. Let's go to the dispositive phrase. Again, it's in subpart A. And that's the phrase, as the court has noted, any person lawfully performing or furnishing. Let's break that down. Person, that's a noun. Right? Lawfully, that's an adverb. And the phrase performing or furnishing, those are verbs and they're present participles. And by definition, a present participle connotes an action that's not yet complete. It's ongoing.
I'm not sure I remember the present participles. I was okay when you were on the adverbs.
I had to brush up on myself, Your Honor, for today's presentation. But why do I start there? Because we know lawfully modifies performing or furnishing. What it doesn't modify is construction or improvement. The word construction appears 11 words later in subpart A, and improvement appears 16 words later. So we just focus singularly on the phrase. We know that lawfully, right, modifies this action. And as I think Your Honors, Justice Donahue was hitting on, it's the person. It's the status of the person performing the action. And lawfully, right, since 1893, this court has distinguished between lawfully and legally. And the dictionary definition of lawfully at the time this statute was passed is authorized by law. It's not legally. It doesn't mean in strict conformance of the law, which in essence is the argument that plaintiffs are proffering. You've got to comply with the building code in order to avail yourself of the construction statute or oppose. That has no grammatic basis at all. But let's go to A1. Justice Brobson, you brought up A1. There is no daylight between a design defect and a construction code violation. They're one and the same. And so under their argument, A1 is essentially mere surplusage.
I mean, almost every negligence action against a contractor usually includes an argument that the standard of care was the building code or the electric code or some other kind of code that set forth the standard of care.
Correct, Your Honor. And what I'm driving at that point home here is they're saying that a construction code compliance or built to code both would implicate A1 and implicate the word lawfully that appears above. Again, there's no textual support for that whatsoever. Now A1's been rendered mere surplusage. But let's go back up to subpart A and the phrase within 12 years after completion of construction of such improvement. It's pretty clear that that's certainly not ambiguous. And what they're essentially doing now, we're writing that out of the statute. That doesn't apply because we're going to toll it. We're going to suspend it until some future date. You come into court and you establish it was code compliant under the code that appeared at the time. But even this idea of code compliance, right, codes haven't existed since the beginning of time. So their own definition is going to exempt any structures built before the adoption of a code. It may seem, well, that's a preposterous premise. Why are you bringing it up? Because over a quarter of the occupied housing units in Pennsylvania were built before 1940, before code even existed. The other obvious flaw in their argument, it exempts professionals which are subject to the building code, like architects. Architects aren't subject to the building code. They also argue in the reply brief, after 3 different interpretations of the word lawfully in the principal brief, that it really means properly licensed and code compliant. Well, now if we're talking about licensure, well, now we've exempted carpenters, because carpenters aren't required to be licensed. And guess what? We've also exempted home builders, because there's no state statute that mandates that home builders are licensed, right? Their argument collapses on itself. And as Justice Weck, you were saying, I think artfully, what they're really doing is collapsing
Did you say inartfully?
artfully.
Oh.
But I talk quickly, so forgive me.
You said it artfully.
You hit the nail on the head, Justice Weck. What they're doing is collapsing the jurisdictional bar with the merits analysis, right? They're merging them into one. And the import of that is now the statute is inapplicable. Because if there isn't a code violation, well, guess what? Then the defendant isn't liable on the merits, and we don't have to worry about the defense. But if there is a code violation, well, defense doesn't apply. So functionally now, we've written Section 5536 out of existence. That is the import of what they're asking this court to do. And if there's going to be an exception beyond the 2 that are enumerated in this statute, the proper place for that to be decided is with the General Assembly, not with this honorable court. I will note what you said in a brief. My comments have been limited today to the second question presented. We think the first question presented has been waived. It was not separately briefed by plaintiffs in their principal brief. It wasn't even meaningfully briefed. There's a single line in their initial brief on the point. And as I think Justice McCaffrey was hitting on, a certificate of occupancy, it has to start the clock, right? And it also has to prove authorization, because it's look at the reproof's record pages 293, 301, and 302. Look at the actual terms of the COs that were issued here. It says that it was built.
Let me interrupt you. I don't want you to misinterpret something I may have said in the form of a question, but is it your position that it starts during the issuance of the certificate of occupancy or at the time of the issuance of the building permit, which obviously is going to predate that. Because I'm just looking at the statute.
Yeah, I understand your position.
Lawfully performing the construction services, that would seem to indicate to me that the issuance of a building permit basically cloaks the construction in lawfully performing. The certificate of occupancy is issued once the construction's completed. The building inspectors come out and make sure that it was constructed in accordance with their building codes.
It's a good question. Let me clarify. So let's start with the building permit. You're right. Building permit's going to go to the authorization, that phrase, lawfully performing or furnishing. Spot on. That is initia. That's proof that defendant is lawfully performing the service at the time they're rendered. As also we'd argue with licensure. In the case of an architect or an engineer, licensure could also establish that. What makes the CO unique is it both satisfies that prong, the lawfully performing or furnishing, and it starts within 12 years after completion of such construction. Because what the CO does, it's retroactive proof, and again, look at the COs at issue here, that says this was performed in accordance with the building code and performed in conformity with the permit and local ordinances, and we know, pursuant to the building code, that the CO is a requirement for the use or occupancy of a residential house. And so the CO is unique in that it can satisfy two elements of the statute, but a building permit, most certainly, Your Honor, would satisfy the lawful performance or furnishing language.
Let me spring to my trap on you. You've fallen into my trap, okay, Mr. Coyle? I've seen situations in the past representing municipalities and townships where a certificate of occupancy has been issued. 5-10 years later, new homeowners come in and they have a problem. They call the building inspector. Building inspector comes out and says, this wasn't constructed according to code, and they issue a building citation. How do you reconcile that?
Because it's a false premise that plaintiffs proffer, that we're saying that a CO is a liability shield.
I'm not suggesting the plaintiffs proffered that in this case. That's why I asked the question.
Well, it's fine. They are proffering it in their principal brief, and our response.
You have a situation where a certificate of occupancy is issued, which indicates that the building was constructed according to code, right?
Right.
And then 10 years later, you have another building inspector comes out and says, no, there's a violation of the code. This never should have been done this way. That's what's causing, and I'll use this, water infiltration.
Sure.
So what's the triggering event? The second building code violation or the certificate of occupancy or the statute of repose?
To trigger the statute of repose, it's the issuance of the CO.
Pardon me. That's the statute. The statute says the trigger is completion of construction.
Yes.
You're saying the certificate of occupancy equals completion of construction.
It's one way in which to establish that.
Okay.
Another way may be.
But the statute does not reference
it doesn't, Your Honor.
And I don't know why you're stretching the argument to say that shows that there was lawful performance. The statute isn't concerned with lawful performance. It's concerned with lawfully performing.
So,
I mean, all the CO does is trigger completion of construction, which is when the statute of repose begins to run.
Our position, Your Honor, which you may disagree with, is it sort of checks two prongs of the statute. Because it's issued, it says it was built pursuant to the building permit. Just as the building permit.
Why do you need that argument?
We don't. What I'm just saying is it can serve two purposes. The building permit absolutely establishes lawfully performing or furnishing.
Well,
in the case of a non-licensed individual.
The building permit and the certificate of occupancy are interesting. They're evidence of something, but they're not the end-all, be-all. I mean, I could have someone come into a house and do plumbing work on my house. They don't need a building permit to do plumbing. Some municipalities may require it, some probably don't. Nor do I need a certificate of occupancy when the plumbing is done. I mean, those are just can be evidence of lawfully performing, can be evidence of when it was completed, but that's really not necessarily important in this case. What's important is, did the contractor here was the contractor lawfully performing the services, of which a building permit might be evidence, it may not be, there might be other things. And when did the statute of repose begin? It began on completion. And I don't think there's any dispute about when completion of this project happened. I don't care whether there was a certificate of occupancy or what. I mean, You know, I'm not sure why that matters for purposes of constructing the statute.
I don't disagree. What I think Your Honor is hitting on is a point we try to make in our brief, which is, in some respects, we've asked for a narrow holding, because there's any number of permutations, fact patterns you could come up with as to how you could, what would implicate the lawfully performing or furnishing language of the statute, and what would arguably implicate the within 12 years after completion of such construction of such improvement language in the statute. There's any number of fact patterns you could come up with. And so that's why we sort of urge the court to say, you know, you may not need to wade into all of that, right? In the case of a brand new single family house
it's just evidence. It's just evidence. It's evidence to show the legal significance of the statute being satisfied.
Correct. And what we're not saying, just some clear, like Justice McCaffrey's earlier question, we're not saying it's a shield for liability. Right. We're just saying it starts the clock. It triggers the 12-year post period.
All right, any other questions for Mr. Coyle? Mr. Bashman and Mr. Coyle, very well argued. Thank you so much.
What do I have here? I forget. Yeah, yeah. You know what? Coke Zero.
In this discretionary appeal, appellant received benefits from a housing authority's Section 8 housing voucher program from 2017 through 2021. Under this program, appellant was required to disclose any changes in her income to the housing authority. However, throughout the time she received Section 8 benefits, appellant did not disclose income derived from her soap business. In 2021, appellant's case manager discovered her business, and she was charged with theft by deception and false swearing. Appellant was convicted of both charges, but appealed only her theft by deception conviction, as she did not dispute at trial that she misstated that she lacked income. The Superior Court affirmed, concluding that the evidence was sufficient to sustain her theft by deception conviction. We're asked to address whether to sustain a conviction for theft by deception under these circumstances, the Commonwealth must prove that the individual's failure to disclose income affected the amount of public benefits received. Please proceed.
Good morning. Eric Kloss for the appellant, Abani Gaspard. With me is co-counsel Anila Ramos. Both of us are from the Monroe County Public Defender's Office.
Welcome.
A lie must cause harm. This is an explicit requirement of the theft by deception statute. The government was required to prove that Abani Gaspard received more housing benefits than she was entitled to in order to sustain a conviction for theft by deception. The Superior Court held that it was enough that Abani merely might have received a benefit she was not entitled to. This was error. The requirement to prove a difference in benefits is a plain reading that stems from the language of the statute. This theft by deception statute provides that a person is guilty of theft if he intentionally obtains or withholds property of another by deception. The statute goes on to define deception in subsection B and states that the term deceive does not, however, include falsity as to matters having no pecuniary significance or puffing by statements unlikely to deceive ordinary persons in the group addressed. A lie about an entitlement disbursement lacks pecuniary significance where the applicant was entitled to the disbursement even if the truth was supplied in its stead. Welfare benefits are a matter of statutory entitlement for persons qualified to receive them. This has been a recognized principle of our law for many years, dating back to the due process rights to such entitlements recognized by Goldberg v. Kelly by the United States Supreme Court. Entitlements are a legal right to property granted to statutorily eligible individuals lacking critical resources. You either will receive them or you will not, based on the statutory eligibility. The purpose of the statute has long been recognized that it requires that there be harm caused by the lie. Where there is no harm, there is no violation. The Superior Court in Commonwealth v. Joy, following this court's decision in Commonwealth v. Gallo back in 1977, interpreted this requirement both on this court's decision in Gallo and also on the comments to the model penal code for the theft by deception statute at that time. And the court in Commonwealth v. Joy said, for example, a salesman's misrepresentation of his political or fraternal affiliations in order to effect a sale are characterized as without pecuniary significance because such representations do not affect the nature of the property that a party receives. For instance, I have used the example in thinking about this and preparing of this case. Suppose Justice Brobson and Justice Wecht went to the opera together.
God forbid.
The opera. Justice Brobson apparently dragged Justice Wecht to the opera, and they're going to see Les Miserables. Justice Brobson checks his old hat into the coat check area. And afterwards, Justice Brobson's so excited about having seen Les Miserables that he goes to buy souvenirs. He tells Justice Wecht, "You may have my old hat." Justice Wecht proceeds to the coat room and says, "Hello, I'm Justice Brobson. Please give me my hat." Okay. Justice Wecht is already entitled to the hat. He's been given the hat by Justice Brobson. Even if he lied to the coat room check person, that has no pecuniary significance because he's going to receive the hat anyway, and if he had told the
I'm just going to tell you right now, that's an unpersuasive hypothetical.
All right. Not so many theater fans, I guess.
Well, Les Mis is not an opera.
You acknowledge it's theater, not opera.
I misstated Les Mis, I'm sorry. I liked it because it was about a good thief, though.
Yeah. It's good. That's very good, actually.
Yeah.
Scalia and Ginsburg loved opera. Brobson and Wecht does.
Oh, man. I was accused of Scalia-isms the last time I was before this court, too, so I guess that's consistent. The example is silly, perhaps, because no one cares about those situations because they're not harming anyone. When the state is presented with a situation such as this, where there is an entitlement and there is no clear harm, this is not something that the legislature is targeting under this statute. And some of the key testimony in this case actually was solicited by the Commonwealth when they were discussing the matter with the Housing Authority on the stand. And I believe the Commonwealth thought the answer to this question was going to be she's ineligible, but instead, when the Commonwealth asked, after Ms. Gaspard had voluntarily provided information about her income, receipts, and things of that nature after it was discovered by the Housing Authority, the Commonwealth asked the Housing Authority employee, was there a determination that she was not eligible for housing assistance anymore? And the answer to the Commonwealth's surprise, I believe, was no. We never made that determination. And the Commonwealth then pivoted in their closing and said, well, you know, it's not about whether or not she was entitled to it or would have received it anyway. It's only about whether or not she lied. And that is why we're not challenging and did not challenge the false statement to public authorities charge.
Because she did lie.
Yes, she did. I mean, Ms. Gaspard maintained that on the stand that she was confused. She thought it meant profit, not income. The jury didn't believe that. That was their right to not believe that if they want. Also present in the exhibits submitted by defense was some forms from the Office of Income Maintenance where Ms. Gaspard had disclosed for purposes of SNAP and Medicaid benefits her income from the business because she paradoxically believed that she did have to disclose it to one agency but not the other. And so
That's why the jury didn't believe her.
I think the jury could have gone any which way in this case. They didn't go for us, unfortunately, but nevertheless, the pecuniary significance requirement of the statute remains. This requirement, I think, is not only part of the definition of deception, but is also implied by the word by. So it's a theft by deception. That, in my view, is a causative requirement in the statute, that it has to have been obtained because there was a deception. By being as a preposition implying the means or the agency of. So it had to have been caused by the deception, and if the result would have been the same regardless, it was not. This causative requirement is also borne out in other sections of our laws regarding theft. We have two sections, one dealing with grading in 3903, and that section grades the harm caused by the lie based upon the money, the pecuniary significance. And when it's over a certain amount, it's a felony of this nature, and when it's below a certain amount, it's a misdemeanor of that. So that requires a causative amount to be implied in any theft charge, but specifically in theft by deception. Also in our restitution statute in 1106, it's only things which are a direct result of the harm caused by the offense, which is going to be awardable in restitution. So really all parts of our law are pointing to this causative requirement, which is implied both by the by in the theft by deception and also specifically defined in the word deception in the statute regarding pecuniary significance. And this is consistent with what this court in Gallo said some 50-some years ago. And Gallo stands for the proposition that deception has to affect the transfer of property. In Gallo, a salesman cold called a Mr. Levito. The sole proprietor, he represented himself as an executive for a national publication. However, he was in reality the sole proprietor of someone who made brochures for advertising for businesses. This representation was made. Mr. Levito purchased brochures from Mr. Gallo, and Mr. Gallo was eventually convicted for lying and theft by deception in that. However, this court overturned because Mr. Levito said on the stand that he was impressed with the quality of the brochures, and essentially he would have bought them anyway. So it wouldn't have made any difference, the lie that was supplied, just judging the case on the truth of the interaction. And so there was no pecuniary significance, and there was not a theft by deception.
Counsel, as to the determination of pecuniary significance, Judge King on the Superior Court found that the housing authority could not investigate whether Gaspard had a net income from self-employment because by failing to disclose her business income, she prevented the housing authority from acquiring information which might have affected her entitlement to Section 8 housing. Could you comment on that?
So I think what has been a focus of both the lower court and the Superior Court in this case is what's the provability going to be for the Commonwealth in these cases going forward? And I'm not saying that the Commonwealth ever has an easy job in any case, though sometimes they do, but the principle is that they have to prove their case. And if this is a requirement of the statute, which it is, they must prove it. And it's not actually going to be that hard. Anytime someone is charged with theft by deception based upon lying about income on a welfare disbursement application, the state has discovered that there was income. The state is aware that there is income, and then they have all their normal tools in their toolbox in order to determine how much income there would be. There could be warrants for bank account records. There could be simple interviews with defendants. Ms. Gaspard, in this case, was extremely accommodating, because when the housing authority called her phone, the answering message was above the bar soapery. I mean, she wasn't doing a very great job of concealing this. And then the housing authority employees said, "Do you have such a business?" And yes, I do.
She came clean.
Yes. Finally, a joke about above the bar soapery. I was expecting like something about above the law, but I like the.
She wasn't trying to scrub the record.
We're going to go all the way down this slippery slope. Anyway, so they had a nice little conversation with Ms. Gaspard, and she said, "Well, here's my income receipts from the app I use to sell things out of my brick and mortar store in Monroe County." She actually got a spot in a news article, which is one of the things that was discovered, I believe, and she had like a little blurb interview about above the bar soapery and how she was trying to make it a success in Monroe County. It was manifestly not a success, but she derived.
It's ironic that she was convicted of false swearing when she was so forthcoming in other ways.
Well, as a defense attorney, sometimes you're very sour grapes about the jury getting it wrong, but that is their purview to get it wrong or right if they want. And as I said, we're not asking the court to revisit it for that reason.
Well, that one, you're not. First of all, it's a second-degree misdemeanor, right?
Yes.
But also that you're not contesting, and you don't have to contest on this appeal that she lied about her income. That's the false swearing.
Right.
That's right.
Yeah.
Yeah, so we're not contesting that, but the state, again, the state has all its normal methods of investigating whether or not something's true or not, witnesses or any other manner. So it's not the housing authority that needs to investigate and prosecute these kinds of things. They're referred to, official criminal investigations. In this case, I believe it was the Monroe County District Attorney's Office Detectives Division, in order to do that. And they had.
So it doesn't matter in terms of the Superior Court's analysis. It's not so relevant whether the housing authority had the ability at the time to investigate and determine because of her lack of, lack of candor. When certainly between that point and trial, the investigators from the district attorney's office and police certainly had an opportunity to determine that.
That's absolutely correct, Your Honor. And, I think in this case, ironically, all they had to do to either prove Ms. Gaspard guilty or prove her innocent was to have crunched the numbers that they had in front of them. They just didn't.
Well, and also, isn't your answer also it's not her job to help the prosecutor?
That's certainly true, Your Honor. But, in terms of concern for whether or not the prosecution will have a fair opportunity to investigate and prosecute crimes like this, I think they certainly do. Yes, Your Honor.
Hasn't Ms. Gaspard's failure to put forth this income, doesn't that handicap the Commonwealths in their ability to determine whether she is eligible?
I'm sorry, could you say that?
Isn't her failure to provide that information, doesn't that handicap the Commonwealth's attempt or ability to determine her eligibility? Because what you're saying is we could have this discovery, which means in every single case, the Commonwealth will now have to subpoena bank records. That's not going to happen.
Well, I'm not sure that will happen in every single case, Your Honor, but I do have a somewhat cheeky response to that, and I mean no disrespect. It is always an inconvenience to the Commonwealth when the defendant does not help the Commonwealth prosecute them. So it's a normal course, though. I mean, a lot of my clients, unfortunately, help the Commonwealth prosecute them very much. And say all sorts of things that if I was standing there, I would hit them with a newspaper and say, please don't say that, we're going to exercise our right to remain silent. But this is, when they've discovered something like this, they've immediately got false swearing. Okay, the initial discovery that leads to the idea of charges will be false swearing. And then if they want to prove the measure of harm, which all theft charges require, then they are going to have to do some sort of other investigation. So that is a burden on the Commonwealth, but that's a statutory one.
So you don't believe there's a theft of opportunity that can support the charge, meaning your deception prevented the government from performing a function to determine whether you were entitled to certain benefits, and that was the theft, not necessarily the benefits, but the theft of the government being able to do its lawful job.
Well, Justice Brobson, that's a very interesting theory. I mean, I would say no, I don't think there is, but that wasn't the theory that the Commonwealth proceeded on in this case. That wasn't the...
Their theory was we didn't have to prove it at all. We didn't have to prove any theft.
That's right. They said, you know, this is the value that she unlawfully received, and we don't have to prove that she unlawfully received it, basically.
All right, I think we understand your argument. More questions?
I'm sorry, but as I understand the record in this case, there was a very good accounting of the money that your client made from her soap business. So, so it seems like, oh, this is an easy case. Here's the money, like either qualified or not. It's not a big analysis. But what happens in the situations with people that I'm sure you represent who have these maybe off businesses that they don't have an accounting? They make $5, they spend it. It's all a cash business and there's no records of it. Then that still fall on the Commonwealth to establish that the money that they made increased their income to a level that they wouldn't qualify for benefits?
Justice Money, I'd first like to say that this is probably the only case that I've ever seen where a defendant had their own business that they set up. It's usually it's somebody working under the table for some other business, in which case the Commonwealth then goes to that business and they say, were they doing that? And the business said, yes. What, they didn't report that on their income? I didn't know that and I don't care. Here's all the information. So, but yes, to your question directly, that is on the Commonwealth to prove, again, because all of these theft cases are concerned with the valuation. And if it's not in the initial requirement in the elements, it's at least required in the grading.
Thank you.
Yeah.
All right, thank you very much. Let's hear from Mr. Shuck.
Thank you, Chief Justice. Other honorable members of the bench, my name is Matthew Shuck. I'm representing the Commonwealth of Pennsylvania through the Monroe County District Attorney's Office in this matter. The giving of public assistance is based upon truth and honesty. Without it, the government would have to spend an immense portion of the already limited money set aside for public assistance on investigating potential fraud, reducing the amount of assistance that goes to those in need. Ruling for the appellant would require every applicant for public aid to consent to allow the government to investigate every aspect of a person's life if they are receiving public assistance. The appellant applied for public assistance and agreed to provide information which included income. She chose not to provide it, and because she considered it a hobby. This determination is not the appellant's to make. It is the income that was not reported.
But it is,
Well,
it is your requirement, I'm sorry.
No,
It is
go
your
ahead,
obligation to achieve the but-for causation in a criminal case. I mean, you have to, in other words, how did you show that her failure to report the information you're talking about caused her to receive the $65,826? That's the piece that seems to be missing. In other words, there's no question about the lie. That's how you get the false swearing. But you didn't charge, for your second count, you didn't charge welfare fraud. You chose, for I don't know what reason, to charge theft by deception. So you had to prove the causation of how she received this $65,000 and change. What did you do on that?
Justice, the Commonwealth is limited in its ability to investigate, as us has already pointed out. We would essentially need search warrants for everything.
You have the ability to get all the warrants warrants you need.
To an extent, Justice, there would be things outside of the Commonwealth's ability to subpoena and seek warrants for. And it would ultimately require in every single case where there's any potential theft, if not all cases, for the Commonwealth to seek out very intrusive requests from every person seeking public assistance to look through.
So we should ignore the fact that the Commonwealth has failed to meet its burden of proof because it would be inconvenient for the Commonwealth to do its job and investigate and prove it beyond a reasonable doubt?
Justice, it isn't that we're asking that the burden is reduced. It is more so that it is virtually impossible, as people do work off the books. People have illicit income that they would never report. They have potentially working outside of the Commonwealth. Potentially they receive income from outside of the United States in its entirety. There would be no possible venue for the government to ever gather that information.
How do you meet your burden of proof then?
Let's say instead of lying about income, she had lied about her address or her date of birth. It would seem there's no, you would just, since you're just presuming without showing a dollar harm, there'd be the same conviction for theft by deception, just by implication. Since you think you have no burden to show the financial harm on a theft by deception charge, you could just assume that the lie about the address or the lie about the date of birth also must result in ensuing harm, so she's convicted on that theory too. What's the difference?
Justice, I would disagree, as there would be no pecuniary harm, no matter what, as a result of lying about the address or date of birth. Whether someone reported they were 39 or 49, it doesn't affect their benefits.
Either way, your theory, to convict this person of a felony, your theory is the court can just presume a dollar amount of harm without any proof of that. So I don't see the difference. The lie is about the date of birth, the lie is about the name, the lies about income. If the lie is enough for theft by deception and you don't have to prove financial harm, why does it matter?
Justice, it is quite literally impossible for us to determine the financial harm, as all of the information is in the sole possession of the defendant.
One more thing then. Why not simply, to get your felony conviction, why not charge welfare fraud instead? Wouldn't that have been more appropriate here?
It could have been Justice, I'm sorry. It is discretionary, though, on what the Commonwealth chooses to charge in certain matters.
Counsel, can I try to help you out here? I want to make sure I just understand, because I don't think the Commonwealth's theory here is completely off the rails. I think what you're saying, or what the Commonwealth's position is the only people that are entitled to benefits are people who are truthful in asking for them. And in the sense they fill out the materials, particularly the material elements of the application, in a truthful fashion. If you aren't truthful, you are not entitled to the benefits. Her problem was she lied about a material element of the application. Even if that lie ultimately wouldn't, if she would have changed the amount, the benefits she received may not have been unchanged. But it's the lie itself about the income that disqualified her from receiving any benefits, and therefore that's the theft. I think that's your theory in the case. She isn't entitled to benefits when she lies about a material element in the application, regardless of how that impact might have been if she would have been truthful.
Yeah, yes, Justice. It would effectively eliminate her.
You don't give benefits to liars. Liars are not entitled to benefits. That's your theory.
In matters that affect the income, yes, Justice.
Right. It has to be a material lie. It has to be a lie that is important to determining what those benefits are, not the birthday, not the name or things like that. But in order for you to be eligible for these benefits, you must be truthful. And if you are not truthful, you are stealing.
Okay, so if that's the argument, on what do you rely to make that argument?
Chief Justice, I'm sorry. The appellant had income. Just because she views it as a hobby rather than income doesn't turn it into something she didn't have to report. When she was gaining the income in 2017 and 2018, she failed to report it and thus would have given up her entitlement. So from that point onward, she effectively was entitled to $0 and was receiving benefits.
Okay, that's your factual predicate. On what legal basis do you maintain that no further proof was required?
Justice, just a plain reading of the statute is that it creates or reinforces a false impression, including the value, by inappropriately giving the value to, she is causing a deception that she was required to correct once she had income.
Okay, so you're relying on the same analysis that Judge King set forth in the Superior Court, that she, in essence, prevented or hindered the prosecution from calculating and investigating and, concluding what the amount was.
That is correct, Judge. I mean, by the very nature, Justice.
It's all right.
First time here. But Chief Justice, I mean, she claims that all of her income was by Square and she could report it, but it was a storefront business. Surely someone paid cash. We don't know how many people did. We don't know the value of it.
We don't convict people of felonies, do we, on the basis that surely someone did X, Y, or Z. I mean, we don't hit somebody with a big mallet on their head because they lied. I mean, she's convicted of false swearing. That's over here. That's a misdemeanor. Nobody did a calculation. There are forensic accountants out there. Nobody gave us a calculation of how this alleged unreported business revenue affected her Section 8 benefits, if at all. We don't know, for example, if this business operated at a loss. Now you might say, by golly, she must have made money. That you can say that all day long, but that's not proof for a criminal conviction. So is there something about Section 8 benefits that we don't know that would make it just obvious beyond a reasonable doubt that any unreported business revenue would automatically affect her benefits calculation?
No, Justice, I do not know of any.
The question isn't whether she violated Section 8. The issue is, does her conduct meet the elements of 3922, which is, is she guilty if she intentionally obtains or withholds property of another by deception, such that it intentionally creates or reinforces a false impression, or false impressions as to law, value, or intention, or fails to prevent another from acquiring information which would affect a judgment or transaction. So we're not looking at a violation of Section 8. This is strictly a matter of criminal law and meeting the statutory definition. That's your argument, correct?
Yes, Justice, and to respond to Justice Wecht briefly, I will concede that we did not have a forensic accounting done in this case.
I'm not suggesting the statute requires you to hire an accountant. I'm just getting at the property issue that your opposing counsel was talking about. We have this big fat question mark here about this thing called the property of another, and we just don't know. I don't see in this record that the proof of what that property was. It's just presumption that she had to make money on this soap business.
And counsel, you're asking us to create a presumption that what happened here, her lack of disclosure, you're asking us to presume that that had pecuniary significance. But what is the basis for that?
Because the information, in order to properly account for the amount she would have been entitled to, but for her hiding all of the potential information, would mean that we would have had to have a forensics accounting done.
Why don't you like my theory of the case? I don't know why you why you're adopting this. I mean, I understand why, because that's kind of what the appellant is asking you to do. The appellant is taking you down this path, and you're just sort of not pushing back. But it seems to me that the only way you can really prevail, because you don't have the evidence of the but-for, is to take the argument that I'm sort of teeing up to you, which is an applicant who fills out a form seeking something and lies in a material fashion on that form, material meaning the fact that you misrepresented is a fact that is taken into account for purposes of the government doing what it does, and then you receive benefits. People who lie on those forms to the government are not entitled to benefits. It doesn't matter if it would have changed the number at all. You cannot obtain government benefits by lying.
And before you answer that, where in the statute would you?
Well, okay, fine, you can amend my question. I mean, I'm just trying to understand. If that's not your theory, if you're going to go down this but-for path, I think you're in trouble. But I think the case is a little bit closer, and I'm not sure I understand why you're resistant to that.
It's a better argument.
I will accept the lifelines from the court judge, Justice.
Well, one problem you have, counsel, is that the statutory section provides that the term deceive does not include falsity as to matters having no pecuniary significance. So you have to show pecuniary significance. You can't just presume.
Bless you.
Well, this is a discussion we should probably have, but not here. But yes. I think my theory purports a pecuniary significance, which is she received benefits and lied on an application to get them. That's pecuniary. We don't give benefits to liars. Whether the lie is ultimately, if you would have told the truth, it would have changed. But there was a deception on a material element of the application. She received benefits which were pecuniary, and the government does not give benefits to liars. I mean, that's
following that argument. The question, and now I'm a little confused. A person who's guilty of theft if he intentionally obtains or withholds property of another by deception. The property we're discussing, the deception is, my understanding, the basis of your Commonwealth charge, is that, in fact, she obtained the property, that being public housing, which means housing that belongs to us, and she's getting it by use of our taxpayer dollars. By not providing that information, she obtained housing. Whether that pecuniary interest, whether it would have put her in the bracket, is not the issue. The issue before this court is whether did she obtain property, our public housing, did she get to live in it by lying and being deceptive of it? That's the question I understand. Am I wrong or
Justice, I would answer that comment with, that is exactly what she did.
Wow. Couldn't you have said that to me? I would have felt a lot better.
I think he was saying it. It just didn't come out that way.
All right, we understand, and we'll have a nice discussion about this matter in conference. First of all, thank you. This was your first argument before the Supreme Court. You did
It is my first appellate argument, Chief Justice.
First appellate argument. How long have you been with the Monroe County District Attorney's Office?
Just since August, Chief Justice.
Well, they threw you right in, didn't they? Yeah, very nice job, and you're always welcome. What about Mr. Shuck? Have you been with us before?
He's Mr. Shuck.
You're Mr. Shuck. I'm so sorry. Mr. Claus, have you been with us before?
Absolutely.
Yes, I did. I had the privilege of arguing, I believe back in 2021 when Chief Justice Baer was still on the bench.
I see.
Very nice job, counsel.
Yes, very nice job. Thank you. Thank you both. We are now going to take a lunch recess. Mr. Minner, could you adjourn court until 12:30? call the next case, Mr. Minner?
CM versus Pennsylvania State Police, representing CM, Mr. Brian McNeil, representing the State Police, Ms. Anna.
Good afternoon.
Hello, Your Honor.
The Sexual Offender Registration and Notification Act, or SORNA, states that subchapter I of the Act is applicable to individuals who were required to register with the Pennsylvania State Police under a former sexual offender registration law and whose period of registration had not expired at the time SORNA became effective. In this case, Appellant committed a sexual offense in 1987 and began a sentence of imprisonment for that crime in 1995. While Appellant was serving his sentence, our General Assembly enacted a series of sexual offender registration laws culminating in the promulgation of SORNA, which became effective while Appellant remained incarcerated. We must determine whether, despite his incarceration, Appellant was required to register as a sex offender under one of these previous sexual offender registration laws, such that subchapter I applies to him. Please proceed.
Thank you. Good afternoon, Your Honors, Counsel. May it please the Court. My name is Brian McNeil with the York County Public Defender's Office.
A lot of York County this week.
I know, punching above our weight. I represent CM, the appellant. This is a simple case of statutory construction. CM's interpretation of the relevant statute gives effect to the language the General Assembly opted to use in defining the reach and scope of subchapter I. This language is clear and should be applied as written, given its plain and ordinary meaning, so as to exclude him from any duty to register. And in the alternative, to the extent the language is ambiguous, CM's interpretation must prevail under the strict construction required for statutes of this nature, as well as the context and background of the enactment of subchapter I. Starting point here, as I think in all cases of statutory construction, is the relevant language. And here the key phrase is really required to register, because subchapter I only applies to CM to the extent that he was required to register under a prior scheme in Pennsylvania during the relevant period, which is roughly 1996 to 2012. CM's interpretation is clear and straightforward, and that is that required to register means required to register. It means that he was actually under a legal obligation to undertake the act of registration during the relevant period. It's not enough that a prior scheme applied to him or covered him, or even that it indicated that he would have to register at some point in the future. If he was not required to register during the relevant period, there was no legal obligation, and he cannot be said to have been required to register. And that's key for CM, because under the relevant provisions, the duty to register did not kick in until after release from incarceration, or at least until such release was imminent. And CM never got anywhere near that point during the relevant period. PSP's interpretation, by contrast, of course, is much broader. And essentially it is that CM was required to register under Megan's Law 2, even though he never did anything at all pursuant to that statute, or that scheme, and he was not actually required to do so. In other words, the PSP's interpretation essentially is that if a prior scheme applied to someone or covered them, that that's enough, and that that means they were required to register for the purposes of subchapter I. The language the General Assembly opted to use, however, supports CM's interpretation and not the PSP's. Required suggests meaningful actual obligations, not unrealized, inchoate, possible obligations that could arise in the future. And here again, it's undisputed that CM never did anything at all and was never required to under these prior schemes. This language should simply be applied as written and exclude CM from any duty to register. And in the alternative, if the language is ambiguous, the strict construction is required under 1 PACS section 1928, which indicates that anytime you have a retrospective or retroactive statute, we need to adopt the strict construction. And here, there's no question about it, subchapter I is explicitly retroactive, meant to apply only retroactively to people that aren't covered under another scheme. Additionally, excluding CM from registering under subchapter I is also consistent with the reason that subchapter I was enacted in the first place, which was to remedy the ex post facto problems that were present based on this court's decision in Commonwealth v. Muniz in invalidating ex post facto application of SORNA. It's a step back from that scheme, and it makes sense to exclude someone like CM because the key motivating principles for ex post facto laws are certainly notice and fairness, or as I think this court said in Muniz, the absence of fair warning. And that's the case with someone like CM, whose offenses actually predate the very concept of sex offender registration. Now, in response to all this, the PSP relies on what it refers to as context, including federal law. But the context, as I just noted, actually supports CM's interpretation in light of the reasons the subchapter I exists in the first place. As for federal law, that's 180 degrees wrong. Subchapter I is actually a reaction against federal law. It's a reaction against SORNA, and it's a reaction to Muniz, and therefore represents a step back from the maximum coverage and maximum punitiveness of SORNA. So to say that it should be maximally expansive is just wrong. PSP also relies on perceived absurd results in this case, and I say perceived because the results the PSP identifies are really not absurd at all. The hypothetical that PSP has put forward and adopted by the Commonwealth Court, all it really demonstrates is that there will sometimes be some incongruity between who has to register and who doesn't. And that's well within the contemplation of the General Assembly. If the General Assembly had wanted a perfect, narrowly tailored scheme of registration, they could have required individualized assessments for each potential registrant to determine whether registration is necessary at all or what the requirements are. But they didn't do that. They opted instead for categorical classifications, i.e. conviction of certain enumerated offenses. And so the General Assembly was well aware that there was going to occasionally be some over-inclusiveness and occasionally some under-inclusiveness in registration. And so to say that we can imagine a hypothetical where maybe someone who some might think should have to register doesn't have to register, and maybe someone who we might think doesn't have to register does, is well within what the General Assembly contemplated when it put subchapter I into effect.
Counsel, is it conceivable that when the General Assembly created subchapter I for the purpose of dealing with retroactive application, specifically, when they used the phrase required to register in that statute, they meant one thing, and that when the versions of Megan's Law that was in effect when your client was incarcerated, required to register, had a different context, a different meaning, is it possible that we should just look at the statute that created the retroactive aspect and determine what did the General Assembly mean when they said required to register under a prior scheme?
I mean, I think ideally we'd have harmony between all the schemes as far as what that phrasing means. But certainly you'd want it, internally within one individual scheme because it's enacted in one session. And of course,
two different statutes, though.
Correct.
Yeah.
And you're looking back, via the enactment of subchapter I, you're looking back at what it means to have been required to register. And to me, that only reinforces CM's interpretation if only because they could have made it so much easier if they wanted to just apply. If someone to whom a prior scheme applied or covered under a prior scheme, they could very easily have worded it that way. The fact that they chose this phrasing, required to register, I think that most people, when they hear a phrase like that, I think they would understand that to mean that you actually had to do something.
Well, I'm not sure if that's. I never profess to be the average reasonable person, but a person off the street who hears required to register under a form or act probably wouldn't put the nuance on it that you're putting on it.
I think it's possible, Your Honor.
I conceive it's possible. I'm just saying I'm not sure it's that clear.
Understood, Your Honor. And that's why essentially our fallback position is that if we have two reasonable interpretations of the same phrasing that really governs the outcome of this case, the court has to go with the strict construction because this is a retrospective statute and a strict construction is explicitly required under Section 1928. So if we can imagine two, competing reasonable interpretations of that same language, then I think CM has to prevail.
Any other questions for Mr. McNeil? All right, sir, thank you.
Thank you very much, Your Honors.
Let's hear from Attorney Kogan for the State Police.
Much shorter. May it please the court, my name is Hannah Kogan, and I'm a Deputy Attorney General with the Office of Attorney General here representing Aplt, Pennsylvania State Police. The parties present the court with two readings of the same language in Subchapter I of SORNA 2, Section 979952, Subsection 2. Ascertaining the plain language of a statute requires reading the words and phrases in context. Here, the statutory language concerns individuals who were required to register under a former sex offender registration law. The correct plain text reading is that individuals who were required to register means individuals with a legal obligation to register under previous laws. The General Assembly in this provision entitled Scope aimed to capture a category of people, those who were required to register regardless of when they began performing that obligation. The text is unambiguous, and that reading is consistent with the language of Megan's Laws 1 and 2 and federal law.
Upon release from incarceration is unambiguous, isn't it?
It is, but it is not in the challenged provision in this case. That language, upon release from incarceration, is actually found in the registration procedures and applicability section, not in the section that is straight up titled registration, which details the category of persons subject to registration that have the obligation based on whether or not they've committed an enumerated offense.
Is the Attorney General of the view, or the State Police, of the view that Section 9795.2 does not apply to this case? I wasn't aware that that was your position.
It does apply, but it applies in context with the provision right before it, point 1, which is entitled registration, and provides who is obligated and who is required to register. The registration procedures and applicability section, where you have the upon release language in point 2, is discussing how to carry out that obligation.
Right, so if you're not released from incarceration, you're not required to register. Isn't that the plain language?
So required to register, we would say, is unambiguous, that it is talking about or capturing a category of people, similar to how if I were to go into my tax accountant's office today and ask, am I required to file federal taxes? He would say yes, because I generally always have this passive requirement. When I perform that requirement, or what my deadline is April 15th, a later date in the future. But first, we look at who is required to register, and then we look at this administrative or regulatory scheme of how we perform that requirement.
Counselor, you keep saying that the plain language is unambiguous. Wouldn't that mean that we'd have to find that the panel erred because of its decision of the quote-unquote the absurdity of CM's interpretation?
No, Your Honor. The absurd results conclusion reached by the Commonwealth Court were simply were alternative grounds. In the first instance, the Commonwealth Court actually agreed and had the same position as I'm suggesting here, that the plain text is unambiguous. You read point 1 and point 2 together. One tells you exactly who is required to register. The second is how you fulfill that obligation and that requirement. So you don't need to do that, Your Honor.
Well, I'm not following you. We can all agree he was in prison from 96 to 2012, right?
Mm-hmm.
Yes.
So by definition, he was not released from prison until that release date in 2012.
Correct, but he was...
He's not required to register because he's not released from prison. Why is that complicated?
I don't want to say it's not complicated, but it is not it's not complicated because he was required to register under point 1 of the section we were discussing of Megan's Law 2. How to then carry out that process, how to fulfill that obligation, is found in point 2.
Let's say I'm sentenced to prison and to a term of probation. that'll start upon release from prison. Am I on probation already when I'm in prison, or when I'm released from prison?
It's upon release, and that's why, again, that's found in registration procedures and applicability, but not in the section regarding who is required to register, the prior section. That is describing all those who have committed certain enumerated offenses are required to register. And we know, too, that the scope provision here is the preliminary language. It's individuals who were required to register.
But he couldn't register. He was in prison.
We know where he was. He was in prison. But what I'm saying is that we're talking about in this provision individuals who were required to register, whereas the registration procedure section, it actually doesn't start with individuals.
But then his registration period would begin to run on that same date.
It does not, and we know that because we have this entire procedure section, which is where we then have the language of upon release.
But then, under your reasoning, by hypothesis, you should be charging a large number of people who were incarcerated with failure to register, because they're required to register under your reasoning. All these people who are still incarcerated on these sex crimes should be charged now with failure to register.
No, because the way this has been consistently read across Megan's Law 2 and then SORNA 1, SORNA 2, and given the history, this is the context. I think my friend on the other side even said you're supposed to read them in harmony, or ideally in harmony. The General Assembly, of course, would want them done in harmony and have uniformity and predictability across the series of laws.
Well, I'm sure they want to do a lot of things. The question is, what did they do?
They did do that here. Each time they've amended or updated Megan's Law, they've meant and they've repeatedly captured the prior, I would say, category of persons that would have fallen under the previous law. And each time it builds upon the prior. And I would say that and SORNA 1 was then trying to also fall into compliance with the federal SORNA, which uses the same required to register language. And the Second Circuit, which I know is not precedent to this court, but they also have said the required to register language is read naturally and unambiguously, the same way PSP is suggesting here, and not how CM is doing it. So
are you saying that your opponent's construction, which was a construction that the Commonwealth Court in a prior opinion had adopted, unreported, I believe.
Smolsky you're talking about?
Yeah, I'm a little familiar with it.
Yeah.
Didn't write it. But that was an unreasonable alternative construction of the statute.
So I don't recall Smolsky saying that it was an unreasonable.
No, I'm asking you if you believe that the construction given in Smolsky and given by counsel for the petitioner here is an unreasonable construction.
I don't know if I want to talk about reasonableness, but I would say it's wrong.
You're going to have to, because if it's unreasonable, then there's no ambiguity. If it is a reasonable alternative construction, then it's ambiguous, and we have to look to other rules of statutory construction.
Right. So in those terms, I would go with the latter, Your Honor.
That it's unreasonable?
No, that it would be ambiguous, that there's two then possible readings of the phrase require individuals who were required to register.
Why don't we then apply the canon
We do.
about retroactive application and construe it with the most narrow construction?
Because we still are looking, I follow the canon of the Statutory Construction Act, and we look at 1921C when a statute is ambiguous. And when the text is ambiguous, we look at the 1921C factors, and here each one of those weigh in favor of PSP's reading. Well,
those are general factors, but there's a specific part of the Statutory Construction Act that deals with retroactive statutes.
So again.
What's your answer to the retroactive statute narrow
The
construction?
most narrow reading, yeah, it is the most narrow reading. I do think, though, that we still have to think about the context and the intent of the legislature, even when we're there. And here they are talking about a category.
See, now you're falling into the trap. You're advocating why your interpretation should win. But the question really is not what you think. The question is, what does the Statutory Construction Act require us to do? And how do we avoid the rule? It's like the rule of lenity in a criminal statute. Now, this is not a criminal statute, but the General Assembly has told us that when dealing with a piece of retroactive legislation, when it's ambiguous, the court must give the language its most narrow reading.
And the narrower group of individuals that CM is suggesting, that is more narrow than the group of individuals that we are reading the statute to say. I don't want to suggest that that's not true, but I understand we want the most narrow reading, but we still
I don't want the most narrow reading.
Sorry, I was going with your hypothetical.
I'm just trying to apply what the General Assembly has told us we have to apply when construing their statutes, because we can't pull them. There's no such thing as true legislative history in Pennsylvania. We have to look at what they have told us to look at, and the Statutory Construction Act says if there is an ambiguity in a retroactive statute, we must give the language the most narrow of the reasonable interpretations. I don't know, unless I am misreading it, it's a fairly clear provision.
I do not believe you're misreading it, Your Honor. But
I don't like it. I don't want it.
Sure. I still think that regardless of when it's ambiguous or unambiguous, you still want to effectuate the intention of the General Assembly.
I'm less interested in the supposed intention, or as you often say, the context, which I think is masquerading for purpose. I'm interested in the text. Can we just agree that Megan's 2 was the law that applied? Can we agree on that?
Sure.
Okay, can we agree that Megan's Law 2 says required to register upon release from incarceration? Can we agree that it says that?
In the procedures section, yes.
Okay, it says that in the law.
Sure.
Okay, and so can we agree there was no requirement for him to register while incarcerated per that statutory language?
Under the procedures statutory language, but also in Megan's Law 2, in the section just before it, it says who is required to register, and it's based off of whether or not you've committed one of the enumerated offenses.
That people under these categories are required to register. The question is he released from incarceration?
But why is that the question when we're now saying required to register is the statutory text and language that's at issue in the scope provision?
Let me ask it this way. Is the obligation to register enforceable while a person is in prison?
No.
If not, how is it an obligation to do anything?
Sorry, you said the obligation or the failure to register?
Is the obligation to register enforceable while a person is in prison?
The obligation exists, but in terms of fulfilling that obligation doesn't begin until they are released.
You seem to be inventing some alternative language. Is it an obligation to do something, or is it not?
It's an obligation, period.
What was he obliged to do while he was in prison?
He was not obliged to do anything because the procedures and fulfilling that obligation, that section does not kick in until they are released. But the requirement in itself exists based off of if they are an individual who has committed one of the enumerated offenses.
Can you analogize this to a period of probation as part of someone's sentence? They're supposed to serve 5 years in prison followed by a period of, 12 months of probation. He's subject to probation while he's in prison, but the actual obligation to begin probation cannot possibly begin until he's discharged from prison. Is that analogous to this?
I believe so, Your Honor. I know less about probation, I would say, and here it is not, those facts definitely are not CM's circumstances, but
Are you telling us state prisoners are serving probation?
No. Those that are incarcerated are...
Subject to it if it's part of their sentence.
Well, yeah, it's part of the terms of the sentence. Sorry.
So is it possible then that an individual can be subject to this registration requirement
As part of the terms of the sentence?
Let me finish. Even though it doesn't commence, that obligation doesn't commence until he's discharged from prison?
Yes, Your Honor.
So when he got convicted of a particular enumerated offense, your position is that he was aware upon that conviction, after his sentence, he is still required or obligated to register as a sexual offender? Is that what you're saying?
Generally speaking, yes, Your Honor. The only slight change here I would say is that based off of the year he was convicted, we're talking about a retroactive provision in Megan's Law 2, which took effect in 2000.
It makes a big difference, though, doesn't it?
Yes, I understand, but we've also said that in Diament that the retroactive provision is fine. There's been no challenge to that, and there's no challenge here to retroactivity of any of the Megan's Law versions. I do understand that if there is two plausible readings here, I would just suggest that it would be contrary to how federal SORNA is read and understand in terms of required to register, and there would be potentially an inconsistency if CM's reading is accepted here with federal SORNA and how required to register is read under the federal SORNA.
We are required to apply Pennsylvania law, not the federal statute. Do you agree?
I would agree. I would just add that here, part of the genesis of Megan's Law and the different SORNA versions was to adopt and incorporate federal SORNA.
It's a little known fact that the feds don't have a statutory construction act. The feds do common law construction of statutes. We have a statute that we have to follow, which sometimes yields different results than a federal court would apply.
I don't disagree with that, Your Honor.
Even if you were right that there's some ambiguity in required to register upon release from incarceration, would not the Pennsylvania rule of lenity require?
This isn't a criminal.
Yeah, exactly what I was going to say, Your Honor. That's my understanding.
That bears not on this at all, in your view?
The rule of lenity would not apply in this case because it's not a criminal statute or criminal provision here.
All right, any other questions? Okay, thank you both very much. Good afternoon.
Good afternoon.
In this discretionary appeal, an employee entered into a bonus agreement with his employer, NCB Management Services, Inc., under which NCB agreed to pay the employee monthly retention bonus installments. After experiencing cash flow issues, NCB failed to make multiple installment payments in a timely manner, but ultimately paid all wages due under the bonus agreement. Thereafter, the employee filed a complaint against NCB, alleging in relevant part that NCB violated the Pennsylvania wage payment and collection law and sought liquidated damages. Notably, by the time he filed suit, all wages owed under the bonus agreement had been paid. The trial court granted summary judgment in the employee's favor and awarded him liquidated damages. NCB appealed, arguing that the employee did not have a viable claim under the wage law because he had no outstanding wages at the time of filing. In a split decision, the Superior Court affirmed. We granted allowance of appeal to determine whether the text of the wage law limits relief to employees who were owed wages at the time they filed suit. Please proceed.
Thank you, Madam Chief Justice. If it please the court, my name is Robert Herron. I represent NCB Management Services, Inc. in this case. Another case involving the construction of a statute. This matter calls upon the court to interpret certain language in the wage payment law that is clear and unambiguous. Specifically, the court needs to focus on 3 sections of the law to resolve this matter. The first is Section 9AA, and that section provides that any employee or party to whom any wages or type of wages is payable may institute actions provided under this act. Is payable is the key to our argument in this case, Your Honors. It means presently owed wages. There's no other construction that's viable in connection with that language. Similarly, Section 9AB allows actions by an employee, again, to whom any type of wages is payable to recover unpaid wages and liquidated damages, not or liquidated damages. So the two are connected. And that's consistent with Section 10 of the Act, which discusses liquidated damages. And in that section of the Act, the legislature provides liquidated damages as an add-on remedy to wages that were due. Not were due at some other time or previously due, but were due at the present time, Your Honor.
What are the liquidated damages for?
I'm sorry, Your Honor?
What are the liquidated damages for? Delay?
It's a penalty. It's a disincentive for employers who fail to pay wages in a timely manner.
Could it be a delay, like a substitute for uncalculable delay damages harm?
Well, I think the Act also provides for prejudgment interest, Your Honor, which is a make-all remedy.
Okay, so you're saying liquidated damages is not really liquidated damages, it's a civil penalty payable to the plaintiff?
Yes, that's what I'm saying, Your Honor.
I guess they probably could have said that. Instead of they could have probably said that instead of liquidated. Damages is not the same as a penalty. It's liquidated damages.
Right. But the court, I think some of the courts have interpreted it. The Andrews case, the Superior Court case, interpreted liquidated damages as being a disincentive or penalty because the employer did not pay wages in a timely manner.
Counsel, can I ask you just to explain to me what you think the phrase "or party to whom any type of wages is payable" means? You said it can only mean one thing.
Well, I think it applies to everything in that sentence, Your Honor. Employee, labor organization, or party.
Well, who would a party be? That's what
Well,
I'm
it could be an
with.
estate of a deceased employee.
Could be an
the
independent
Secretary of
contractor, I
Labor.
suppose. Independent contractor?
An independent contractor, perhaps. But I don't think that, it doesn't make sense, it's not logical for that only to apply to the term party and not the other parties listed in the statute.
How would a labor union, sorry.
It's a party who otherwise would be entitled to wages.
Excuse me?
It's not an employee who we know receives wages. So this party that's being described here is someone other than an employee?
Yes, I think so.
Who is entitled to wages?
Right. Again, it could be the estate of a deceased employee, for example, or the Secretary of Labor if the Secretary of Labor brings suit to enforce a claim for unpaid wages. I think the other point that's important to the court's review of the case is
let me just follow through with that if I can. If you look at subsection B, which describes the actions that can be brought.
Yes.
It refers to or his representative. It says party or his representative. Wouldn't that phrase capture the representative of an estate that you just described?
It could, Your Honor. It could also be
so
a class representative.
Why would you say then party means something else?
Well, I'm only assuming that's what it means, Your Honor. I don't know for a fact.
It has to mean something, doesn't it?
Right. And I think it can be a representative, a class rep. It could be, again, the estate bringing the claim on behalf of a deceased employee. It doesn't make sense to sort of separate out party from the other items listed in the statute. It makes it nonsensical.
How would a labor union be owed wages?
Right.
Excuse me?
How would a labor organization be owed wages?
Well, they would bring the claim on behalf of the union members, Your Honor.
Well, then that doesn't mean the labor. It says your construction would require us to say labor organization
To whom
any type of wages is payable.
Well, I think that refers to, again, the union members upon whom they're representing.
Well, they'd be the employees.
Right. It could be a class of employees, or I think what it says is the labor organization has standing to bring the claim on behalf of its union members.
Except the labor organization isn't a whom. It says a party to whom. So I just don't know how that could read labor organization to whom any type of wages is payable. I mean, I think it's an awkward, awkward construction, and I was just trying to determine whether what the legislature was trying to capture here was some party otherwise not identified here who could receive wages.
Right.
So that to whom any type of wages is payable is just a description of not necessarily in futuro is owed wages, but at any point in time wages were payable.
Well, again, I think the is payable sort of answers that question because it's presently owed wages. I don't think you can rule out the word is in connection with how the statute is interpreted.
Okay, well, subsection A creates a private cause of action, right? That's what we've settled on here.
Yes.
Okay. So what is the action that can be brought? That's under subsection B, correct?
Yes.
What indications in subsection B are there that claims must be due and owing at the time the action is brought?
Well, it says any type of wages is payable to recover unpaid wages.
So you're hanging your entire hat on that?
Yeah, I am, Your Honor.
Okay.
How do you resolve the 30-day grace period for the liquidated damages?
Well, Your Honor, that's a time period under which an employee, in addition to the other remedies provided by the Act, could sue and recover liquidated damages. Section 10, again, of the Act says liquidated damages are an additional remedy available to employees who are due wages.
I know, but your view is that as long as I pay at some point in time before liquidated damages award, even after 30 days, liquidated damages become off the table.
Yes, Your Honor.
So you could go all the way to the day before trial and moot a liquidated damages claim by paying the unpaid wages.
No, I think the cutoff date would be the date the lawsuit's commenced. And that's entirely in the control of the employee. The employee can sue, if he's not paid on the next pay date, he can then bring a suit for unpaid wages. And after 30 days, he can tack on the additional remedy of liquidated
So on the 31st day, if there are unpaid wages and they sue, they get liquidated damages and the unpaid aspect of it is fixed as of the day of the suit.
That's correct, Your Honor.
Okay. Thank you for that clarification.
In terms of subsection B, again, I thought you were going to tell me that the indicator in subsection B that your position is correct is that the claim that can be brought in court is for unpaid wages and liquidated damages.
That's correct, Your Honor.
Well, that's different than relying solely on is payable, any party to whom wages is payable.
Well, that just
I'm looking at this. I'm looking at what action is actually permitted under the statute, and it is an action to recover unpaid wages and liquidated damages.
Right, correct, Your Honor. And that connects the two, and that's consistent with Section 10, which provides the liquidated damages that are an additional remedy to wages that are due. In fact, it's calculated at 25% of wages due.
So unless you have wages due, you don't get liquidated damages.
That's correct, Your Honor.
And that's
at the time of the
consistent
filing
with your reading of B.
Yes, at the time of the filing of the suit, if the payment of wages and interest, and we paid interest in this case, the harm to the plaintiff, the employee, has already been rectified. So there are no longer wages payable.
Well, maybe the harm hasn't been rectified completely, but your argument is simply it was completely in their power to get liquidated damages, and they sat on their rights.
That's
they
correct.
could have sued after 30 days and gotten everything, but they waited and gave you an opportunity to pay and had the suit off.
Yes, Mr. Aita could have brought suit 60 days after the bonus payment was due and argued at that point he was, in addition to the bonus, he was entitled to liquidated damages.
And just for purposes of completion of what's contemplated here, if someone who is seeking action under the Act forgoes a private cause of action, they can make a claim through the Secretary of Labor.
That's correct.
In which case, they obviously need to have outstanding wages. Am I correct?
That is correct, and that's the way the statute's written as well, Your Honor.
And there's no liquidated damages. Instead, in conjunction with that claim for unpaid wages, the Secretary gets to collect certain penalties.
That's correct, Your Honor.
All right, any other questions for Mr. Haran? Thank you, sir.
Thank you.
Let's hear from Attorney Collins.
Chief Justice, members of the court, may it please the court, my name is Patricia Collins, and in this matter I have the honor of representing Marcello Aita, who has done me the favor of joining me in court today, which is always fun. I'm happy to be here to argue this very interesting issue under the Wage Payment and Collection Law. I just want to start by saying that the argument proposed by NCB and the dissent below, it would require this court to read a requirement, a hurdle, into the collection of wages and liquidated damages that is not in the text of this statute, not in any clear and unambiguous way. Instead, as we just heard, it requires some verbal semantics and piecing together of disparate sections of the statute to get to that conclusion, and it's just not built there. And I would posit that this argument doesn't start at Section 9, it starts at Section 3. That's what defines the word payable, that's what says what the requirement is, that's what says what the violation of this statute is. And in Section 3, what it says is that every employer shall pay all wages on regular pay days designated in advance by the employer or on the date as set forth in agreement. And once you fail to do that, to pay them on the date that those wages are payable, that's the first place the statute uses the word payable, you have violated the statute. So payable, in the overall context, the structure of this statute, payable means the date it was due. The payday, the date under the agreement, the date it was due. And there's no dispute in this case that NCB violated the statute by not paying the bonuses when they were payable. That's how this statute is set up. And if you look at the plain language of the liquidated damages section, that built into that liquidated damages section is a chance for the employer to fix it, right, and avoid the liquidated damages. It's built into that they've got 30 days in some cases and 60 days in our case to remedy that situation. And once they don't remedy the failure to pay wages when payable, liquidated damages are due. That's how this statute reads.
Counsel, the liquidated damages clause.
The liquidated damages, I think Justice Donahue is going to ask my question. So
go ahead. You can ask it. Go ahead.
The liquidated damages clause actually defines liquidated damages as 25% of the amount that is payable.
That is due.
If those amounts are paid, what are payable for liquidated damages? What is payable?
What's payable is 25% of the wages that constitute the violations that were payable. The 25% of the wages.
That's not what the statute says, Counsel. I wish you were right, because I really do think that this is draconian, just in terms of what you're looking, to effectuate here. But the liquidated damages are payable on the total amount of wages due. There are no wages due in your case. And to me, that's consistent with the language that says that liquidated damages can be claimed in addition to wages that are due, which is consistent with subsection B, which talks about bringing your claim for wages and liquidated damages in the same cause of action. And it goes on at the end to say, lest we need anything else to say, they're talking about wages that are due, that that amount that's due can be compromised, within the context of the litigation or in settlement.
Sure.
And so, I mean, I'm struggling truly to come to the conclusion that liquidated damages are not tied to wages that are due and payable at the time that the cause of action is brought.
And I'm happy to walk the court
yeah.
through each part of your question.
Convince me.
I'll try to go in order. We'll start with the 25%. It says 25% of wages due. That is the language. That's the calculation language, right, of wages due. But if you go back to the beginning of that section, what it says is that where the wages are unpaid for 30 days or 60 days, as the case may be, then they're entitled to these liquidated damages. And the 25% is how they're calculated. It doesn't say, for example, and recall, this is a remedial statute. This is a borderline interpretation. It has to go towards the injured party and towards its remedial purpose. So it doesn't say, for example, the total amount of wages due on the date that you filed a lawsuit. And actually, Your Honor, it's built right into your earlier, I think it was Judge Brobson's earlier question, as let's change this fact pattern and say NCB decided the day before trial to pay the wages, right? If those pages, am I done at trial because no wages are due? That cannot be what the legislature intended. It would say that. It would say that in this statute.
But counsel, if I could just interrupt, and I don't mean to get too far into the facts, but these were bonuses that were due and owing to your client. My understanding from reading the facts was that when they were due and payable, the company didn't have the proceeds. They approached your client, who agreed you can pay them in the future. You're now going back and saying, well, at that point, even though they were paid ultimately before he filed suit, we're still entitled to the 25% that was due and payable, even though he agreed to it. And I understand what you're saying, and the only reason I'm bringing that up is because you just said yourself, this is a remedial statute. It's meant to help employees. But if you have an employee in this particular circumstance who agrees, I understand I'm owed the money, you can pay it whenever our cash flow gets better. How do we factor that into this particular argument that you're making for 25% liquidated damages?
First, that is disputed, that my client agreed. That was never a finding of fact, and that was a fact that was disputed, that Mr. Aita agreed to the delay of these. That I don't concede that fact.
Did he file suit?
Yeah. Yes, he filed suit.
Did he file suit as soon as the bonus wasn't paid? Did he file suit?
No.
Why not?
But that's not a record in this case, and I submit to you it's not relevant.
Yeah,
There's a 3 years.
I'm asking you that question because you brought up the fact that this is a remedial statute, and basically we want to punish employers with this liquidated damage clause for not paying wages when due and payable.
I'm not saying that. That's what the statute says. The statute says wages are payable on this date, and if you fail to make those payments on the dates they're due, and 30 days or 60 days have passed, you must pay this employee liquidated damages. That is what the statute says.
Is it you must pay them, or you have the opportunity to seek them? Does the statute say they have to be paid in the absence of a lawsuit, or is this more along the lines you can make a claim for unpaid wages and liquidated damages?
I don't want to say it wrong, so I'm checking the language. I think it says may claim, but the employee shall be entitled to claim is the way it reads.
Yeah, to claim
yes.
in a lawsuit.
In a lawsuit.
Right.
Well, no, it doesn't say in a lawsuit. It says
You have-
the employee may be entitled to claim.
How else would they be able to claim them if
They
not
could
in a
claim them
lawsuit?
through the Secretary of Labor.
Secretary of Labor. In which case, you're clearly only entitled to wages that are due and in the procedures before the Secretary.
But understood that that's what the procedure is.
And so you're saying there are two different intents between B and C. Let me just go back to liquidated damages again, the 2060-10. It says where wages remaining unpaid for 30 days beyond the regularly scheduled payday and no good faith contest or dispute of any wage claim exists, accounting for such non-payment. And then it goes on to say you get, in addition, liquidated damages. This clearly anticipates that the dispute over the payment of wages exists at the time that the claim for liquidated damages is brought. I mean, it doesn't say existed or there was a good faith reason for withholding. I mean, it's all written in the context of ongoing litigation. And I'll say it again. I mean, I think this is draconian in the sense that it allows an employer potentially to game the system. But as you just pointed out, as a result of Justice Brobson's questioning, the onus seems to be on the employee to bring a claim to enforce the unpaid wages context. And I just don't know how to read all of these sections together to get you a point where you could bring any kind of action after the wages have been paid.
I believe I can answer that.
Okay.
I was trying to go through the sections as you presented them, but, well, just to the tense of the word exists and the word in addition, there's a couple places where we've talked about things in the present tense. I think it's in point 9A as well. That would require this court to ignore that the way this statute works is the violation is baked in as soon as the payment is late, right? That's the way, according to section 3, the violation is baked in as soon as it's unfixable, right? The violation has occurred.
It's only a violation if there's no good faith basis for withholding or other set-offs or things of that nature.
Well, let me be clear, because the good faith section is only in the liquidated damages section. I mean, the parties might dispute how much wages are due, and you might have litigation about that, but the failure to pay the wages is baked in when they're late. That's the way the statute works. And so
that's consistent with how liquidated damage awards work, right? They're for a violation.
That's right. Exactly. And that is how the statute, I think, is meant to work. So when you see the present tense, I think the present tense is tied to the fact that the violation has occurred. What was the state of play on the date that the wages were due? Was there a good faith basis for the failure to pay? And so I think that's the way to read the present tense in section point 10 and section point 9A, because otherwise the statute's definition of payable in section 3 is meaningless, right? Or it has a different meaning any place you see it in the statute, and that is absurd.
So your argument, and I think it's a decent argument, is that when the statute says unpaid or payable, that's as of the date of the violation. Nothing can alter, once they were payable or unpaid under the Act, they are forever payable and unpaid.
That's right. That's right. And here's the other thing.
But then you couldn't
interject. That's if there was no good reason for them not to be paid. As you know, we've talked about, there was some rationale for why they weren't paid.
Well, that would prevent liquidated damages,
right.
but that wouldn't prevent. But then you run into the other problem, which we completely interrupted you going through all this provisions that Justice Donahue asked you to go through. But then you run into the problem of liquidated damages being in addition to the unpaid wages. If they're already paid, you can't double recover.
Well, I think you have to read that in addition to and the same way you read the present tense, meaning at the time, in addition to the wages that were due at the time when they were payable.
Yep, it has to be in addition to. So you would have to, in addition to getting liquidated damages, getting a ward of unpaid wages, which there are none. Your client had none.
No, I just.
They had unpaid for purposes of the violation.
Right.
But factually, as a matter of double recovery, unless under your theory you also get to recover them again.
No, I
Also
would
get to
never.
recover
that would-
what?
Wages again.
Yeah.
Oh,
That would, no, I'm not arguing for double recovery. What I'm saying is the word in addition to and, that's in two places as well.
But counsel, if you look at subsection B again, which
Yeah.
I don't know somehow, I think it's sort of critical, where the legislature explained the cause of action.
Correct.
It contemplates the liquidated damages claim being brought with the wage claim. In fact, it says so.
Right. It says and in B, in point 9B, and it says in addition in section 10. And I
Correct.
think we can adjust them both the same way. And that is if, one, I go back to my premise, which is the unpaid wages we're talking about is the violation itself, which is baked in on the date that they're late, one. And then two, an employee is always entitled to unpaid wages, to whatever's not paid. They always are, and that is the traditional way that it comes in. And if the legislature had intended that there be some, that it's got to be outstanding on the date of filing suit or the date you go to the Secretary of Labor, like it did with the Secretary of Labor, you got to be unpaid on the date you go to the Secretary of Labor, it would say that here. It
Why
would
would
say
that be
here.
different? Why would it be different?
Why would the Secretary of Labor? Because you're using the resources of the Commonwealth to pursue wages that were already paid. I think
And what is the language that you're relying on in subsection C, which is not a private cause of action, but going through the, it's in the alternative. So that to me means it's an alternative to what you could get in subsection B. Instead of bringing a subsection B claim in the alternative, you can go through the Secretary of the Commonwealth.
That's right, and that section, C, has built into it that you need to be paid that. You need to have some unpaid wages. But that's not the right way to read B, because that requirement isn't in B. Why would it be in C? Why wouldn't they have repeated that requirement in B? The legislature.
What about B? Actions by an employee, and I like your theory, and it makes sense in the sense that when you're talking about wages payable, you're talking about timely payable and at the date of the violation. I get that. But you run into the other use of the phrase unpaid wages, which is different from wages payable. It says wages is payable to recover unpaid wages and liquidated damages. They have to bring, at least under this civil cause of action that is authorized, an action. You can't just bring an action for liquidated damages. This says you have to bring an action to recover unpaid wages and liquidated damages, not or.
I don't read this as excluding a claim for liquidated damages only.
Well, how do you reconcile to recover unpaid wages and liquidated damages?
I think it's meant to be inclusive, not exclusive. In other words, an employee has these remedies available to them. You can go file a suit, you can get unpaid wages, or you can get liquidated damages.
well, and if the converse were true, then your example of settling on the courthouse steps, someone pays the unpaid wages the day before you go to trial, that would eliminate the liquidated damages claim. That can't be true.
That can't be true.
Well, no, but by that time your suit is joined. By that time, when you file the suit, you have to seek recovery of unpaid and liquidated damages.
Exactly.
With all due respect, I don't see that language here. I don't see when
you just disagree with how I'm proposing to read unpaid wages and liquidated damages. You think it's unpaid wages and liquidated damages and punitive damages or blank. You're reading it as sort of an exclusive long choice list.
Right, and the legislature had available to it the opportunity to say, should they remain unpaid on the date of filing suit. If the filing suit appeared anywhere in here, maybe I'd have a harder time with this argument. But the way it's struck, and I think our interpretation is right, and the Superior Court was right, and the trial court was right for a couple of other reasons. If you look to the attorney's fees provision, just by way of example, how the statute is structured, the attorney's fees provision is keyed to judgment. So that's a place where the General Assembly went out of its way to put in a timing requirement. You need to have a judgment in order to get your attorney's fees. So obviously that drafting was available and known to the legislature when they drafted this section.
How would that make, how would attorney's fees ever be awarded prior to judgment?
There are other statutes out there, remedial statutes in the world, that have different language relating to attorney's fees. But the timing piece of this statute is that you have to have a judgment.
So you're saying unpaid wages in subsection B means unpaid wages on the date
that they were due. Unpaid wages on the date that they were due.
But it's an action to recover unpaid wages.
That's the problem. It's an action to recover unpaid wages, not wages that are due, which relates back to your original argument, which I could buy into. But this is talking about something else. It's talking about unpaid wages. And then you go to liquidated damages, and it's based upon unpaid wages.
And I don't believe it. I think the only way to look at unpaid wages is a calculation of what was payable, what was due on the due date. That is the unpaid wages to which this statute is referring. Otherwise, you arrive at an inconsistent result.
What's the inconsistent result?
That the statute is built around remedying. That the statute is built around the concept that the violation occurs on the date it's late, right? That's the violation.
And it's on the employee to enforce the provision.
Of course, that's not, we're the Secretary of Labor, but it's on the employee to either go to court or go to the
Even if it's the
Secretary of Labor.
Secretary of Labor, it's the employee. Somebody has to go to the Secretary of Labor.
Correct. That's correct. It's on the employee to do those things. But the timing that the employee chooses is not relevant. This statute has a 3-year statute of limitations. That's the only relevant timing.
It's relevant in the sense that you might give up the opportunity to get, quote, to recover unpaid wages.
I'm so sorry. I'm not sure I understand.
It's when you initiate the lawsuit is relevant to whether you can, quote, recover unpaid wages. Your point is, I can always sue to recover liquidated damages, even if I don't have unpaid wages. But if you delay, you might be avoiding, you might lose the opportunity to seek unpaid wages. But you always have the authority to get the ability to get liquidated damages.
Right. Well, presumably the employee, as in this fact pattern, maybe already got them from some other mechanism.
Right, because you didn't sue right away.
Right. And there's lots of reasons that are not dilatory that an employee might not have filed a claim yet. Maybe they didn't have the money to hire a lawyer or pay the retainer.
I think that's why you could go to the Secretary of Labor. I think that's why the statute provides for just give notice to the Secretary of Labor. And then the Secretary of Labor takes over and processes the claim. You lose your right to liquidated damages under that scenario, but it's a true self-help.
Well, that's presuming that a regular employee, out there doing his job every day knows that this remedy even exists. I mean, that would be quite not consistent with the remedial purpose of this statute to build in a gotcha.
Well, there's no gotcha. I mean,
for time.
An employee to bring a lawsuit in court has to know the remedy exists. There's just two different ways to approach a remedy under the statute.
Yeah, my point being, yes. My point being that that's something lawyers know. That's not something ordinary employees know.
Are there any other questions for Ms. Collins? All right, thank you both. Very well done.
Thank
This will conclude our spring argument session in Philadelphia. I'd like to thank PCN for broadcasting our sessions for educational purposes to the public. We appreciate that. I'd like to thank our court crier, Brian Minner, and our prothonotary, Caitlin Gorman, along with our court security, John Evans, Scott Town, and Gary Shovlin, as well as the Philadelphia Police and their Special Dignitaries Unit. Mr. Minner, you may adjourn the court.
Court is adjourned.